There is some correction, my lord. Some pages are missing. I have just check up, my lord.
Understand. You want to do it right now or adjournment?
No, my lord, on Monday, my lord.
Monday.
I may be allowed to
Prayer of
correct.
Mr. K.C. Roy, then council petitioner, adjourn to be listed in the next week.
Okay, my lord.
The corrections, if any, may be
In the bench section.
incorporated by the Learned Council.
Oblige, my lord.
Where will do it? Before the registry?
Bench section, my lord.
Maybe your lordship, I have to mention
Which
again
two?
15, my lord. In this case, my lord, I want to withdraw this IF petition, my lord.
Let it be called, we will pass the order.
I want-
Let the item be called, we will pass
Okay,
the
okay.
order.
Yes, ma'am.
Yeah, very good, Lordship. Lordship, I beg to mention item 4, Lordship. We have filed affidavit yesterday, Lordship. It may be bring on records.
It's stated by MSR Shahal and Council petitioner that an affidavit had been filed by the writ petitioner, which is not on record, list along with the said affidavit.
Item 1 for motion.
May I please, lord? Lordship, this is the second writ petition, lordship.
Hmm.
This is the second writ petition, lordship.
Why?
Kindly see the page 65. Your lordship's order in earlier writ petition.
Second writ petition is not maintainable.
Lordship, your lordship directed to appear before the learned court,
Ah.
the tribunal.
What did you do?
We have appeared, lordship, and executed that
It is
document.
around mere reference to
Lordship, kindly see the page 65 earlier.
65.
Five.
65 is the only the cause title. Now what happened?
Lordship, now page impugned order, page 70 maybe.
No, what happened?
Lordship, we have executed, lordship, the Jamabandi. That was not considered on the ground.
Which page, which line?
Page 70, lordship,
70.
70.
Evidence accounts. Huh? Where is that computer generated document? Which page?
Kindly see that is not computer generated.
Which page? Let us see what you have
Page 69 of the record may be seen, lordship, the original copy. Page 69.
Electronic evidence of it. Yeah, it's like it's 65B. All the engineering is contained in an electronic record, which is printed on a paper stored recorded or Nowadays, Mr. Payeng, which document is not generated in a computer?
Lord,
Even in, just a minute. Even the writ petition you file is generated in a computer. Do you mean to say this writ petition now has to be 65B has to be followed?
my lord, I
What
am-
will happen in this world? Now, almost entire thing is computer based. Okay. You go and purchase a bus ticket, even that is computer generated. Do you mean to say the conductor will now ask you, prove it under section 65B, that this is a proper ticket, or else you get down from the bus?
my lord,
If we have to follow this tribunal member, bus conductor will have to do that. Railway tickets are computer generated. So the TT will put down a man, or else ask him to prove it under 65B. Where is the world heading?
my lord,
These things are done to make things easier or to add to the confusion.
Lord,
And that
This
too, you
such-
see, it has a clear round seal of the circle officer.
my lord, I don't have this copy, my lord.
We have it. You can please look at, take it of the option. Let him
Lordship,
take a
I-
look at it.
Lordship, I,
Just a minute. We are interacting with him. Take on the option.
and in fact, my lord, the,
Just a minute, we'll hear you. We'll not only hear you, we may pass some order against this tribunal member also. A time has come for personal appearance of these people one day.
Let me exhibit here. This is not a computer generated one, my lord. This is not a computer generated, or this cannot be,
This is what we are trying to ask you.
this is a certified copy for.
Computer generated document and a printout of anything are too different.
When a computer generated copy, my lord, it doesn't contain seal and signature. In that case, my lord, there must be a certificate from the concerned that it is
Definitely, yeah.
genuine and it is printed, it is taken out from my custody.
Just a minute, let us see what are there. And shall be admissible in any proceeding without further proof or production of the original. It is not for rejection. 65B doesn't say you reject it. 65B says that if it is a computer generated printout, without following the conditions of 65B2, that case, what will you have to do? You'll have to ask the person to give further proof, or you call for the original. Tribunal has the power to call. I think provisions are very clear. They exercise the power of CRPC and CPC. CPC gives the power to the tribunal to call for any original record if necessary.
Definitely.
Where is the power of the tribunal to dismiss in this manner? And that too, when there is a specific direction from the High Court that you consider this document. Let us issue contempt notice to this man.
My lord,
Mr. Payeng, you did not defend him. Let us issue contempt notice to
lord,
this member.
I am not defending my lord. Just that. My prayer is that,
We are on the conduct of this particular person.
my lord, probably there is a misunderstanding in the, my lord,
Then
Okay, sir.
remove this man immediately.
my lord,
If he has any misunderstanding of the law and that to the direction of the High Court, remove this man immediately if he doesn't understand. Let somebody else be appointed. There are hundreds of people who are willing to take up these jobs. Qualified people also.
let me get an instruction to this effect, my lord, your lordship make.
Sorry,
Let me get an instruction to this.
we'll take up today itself.
my lord.
Another question, Lordship, can
Ask this person to immediately respond. We'll hear you, other person will hear you later on. Let us first sort out this issue.
My
No,
lord, may I
you're not going over. And don't you think that's a certified copy also? It's containing the seal of the circle officer? It's
this is-
containing the requisite stamp being paid?
This can be accepted as a matter, this, my view is
So
that, my lord,
once
this
it
is
is a certified copy, does section 65B come into place?
That's my lord, if 65, it is a certified copy, it doesn't come.
So High Court also issues all computer printout, whatever certified copy is given to you over orders is always a computer printout.
Only.
Then why don't you apply 65B there? He should have rejected a High Court order also. Definitely it was computer generated. Why didn't he reject it? That bring further proof and bring the record of the High Court before me now, whether this order is passed or not. Why did do that?
My lord, I may be given a copy of this, my lord, Xerox copy of this one. I have-
Take a Xerox copy, we'll take up at the end of the list.
Lordship, for a moment, Lordship,
Sorry,
page 72 may be seen, 3 lines, Lordship, of the order.
we have read the order.
No, Lordship, this is the very important 3 lines, but kindly see. Page 72. In earlier Lordship, in earlier repetition, your Lordship rejected the tribunal's earlier order, Lordship. Now, Lordship, page 72, last 3 lines. So considering the above discussion, it is hereby inferred that the OP has miserably failed to prove her case, and as such,
Next.
the opinion dated rendered in the present case remains uninterfered and unaltered, Lordship.
Item 2.
We'll take up after some.
Well, in this matter, my lord, some time is required because some document is to be placed. I am appearing for the first time. And my lord, although.
You want to
yes-
file some extra document?
Yes, ma'am.
Mr. S. Nath, line council petitioner seeks for an adjournment to bring on record certain further documents which the petitioner intends to rely upon.
3 weeks time, my lord.
2 weeks.
3 weeks. time. Up to obtain the cert.
2 weeks. If necessary, we'll.
Okay.
Item 3.
My lord, in this case, the governor was directed to file an
Gambura
affidavit.
Pachim
Yes.
filed an affidavit before the stating
Well,
sources
government has-
knowledge and record, which is surveyed.
It's communicated. to the
Also make
deputy commissioner.
available the certificate. You are required to file an
Yes.
affidavit, Gambura,
Yes, my
PK
lord.
Medi.
Some more time may be granted, my lord.
Mr. G. Paying, Land Council Home Department seeks for some further time to enable the Gambura Postim Deoli village to file the affidavit as required by the order of 3/5/2023.
The meantime, my lord, the petitioner will be
Sorry.
protected, my lord. It's because, my lord,
We
she's a
don't know.
lady, my lord.
Protection you'll get only when you make out your prima facie case.
Yes, my lord, she may not be arrested, my lord, at this sisters, my lord.
Mr. Council,
Yes, my lord.
we'll pass an interim order when the prima facie case is made out. For that purpose, we want,
Petitioner, my lord, she is the daughter of an Indian parents, my lord. And the names of her parents and grandparents, my lord, were listed.
Mr. What are the 3 principles of an interim order? When an interim order is passed by a court?
The living certificates, my lord, issued by
Sorry,
Tabura
please.
as well as, my lord. Secretary.
You are answering something else. What are the 3 principles of interim order or injunction? Sorry,
Private is satisfactory.
prima facie
Yes.
satisfaction. So to arrive at the prima facie satisfaction, we are requiring this document. So let the document come. How can the interim order precede the prima facie?
That document is with the petition.
Sorry.
At page number 54, my lord, and certificate.
We,
my lord,
this
for the
is
Tabura.
found to be little short of being acceptable. Therefore, we pass this order.
Yes, my lord. Yes, my lord, if it is fine, my lord, the petition only may not be attested, my lord, at this stage.
You are again back to square
That
one.
is the only support, my lord.
The interim order for the present stands rejected in as much as the prima facie case is yet to be made out without the documents being.
Like that, my lord, this may not be. My lord, next week.
Next time we'll
Next
see.
minute I will
Definitely
try.
will pass it if it is
Yes,
there.
my lord. This-
Item 5.
My lord,
Sorry.
next date, my lord. interim
Next
order.
date, definitely. Next date we'll see. And Mr. Pine, find that.
Date may be given, my lord.
Date will be given. Yes, Mr. Ahmed.
JP Lordship.
Mhm.
Father name is Josimuddin Sheikh and.
Page
Josi
number?
Sheikh. Page 17, my lord.
Page 7.
And name is very.
Number
18,
65, Josimuddin. Okay, he is the father.
Yes, my lord.
And the
also
petitioner is
total-
Jamila. Which document will show? Jamila is the
My lord,
doctor
one
of
Jamabandi copy, my lord.
page number,
Page 30, my lord.
page 31.
31.
এই বাকিখিনি একে লিখি
Earlier.
EMI, right? এটা line লিখি ল'বা. In the writ proceeding, the petitioner relies on the voters list of 1965 of village Khudnabari, which contains a name of Josimuddin Sheikh at page 87, and also a Jamabandi in respect of a plot of land of village Khudnabari, wherein it is provided that land had also been mutated in favor of Jamila Begum, daughter of Joshi Sheikh, in place of Joshi Sheikh. It is claimed that Joshi Sheikh of the Jamabandi and Josimuddin Sheikh of the 1965 voters list are one and the same person on a prima facie case being made.
Item 6.
No, internet. Notice interim, I will call for the records. Sirajul Islam.
May I please, Lord?
Yes, Mr. Shikdar.
My lord, annexer 3 is 24, total list of 1965, 65. My lord, Amsar Ali is father,
Amsar Ali father.
father, Sohaib Ali is
65
the
village
paternal uncle, Sakina is mother.
Maleka Ding. And which document will
My
show
lord,
Sirajul
at-
Islam?
At page 58, total
Eight.
list of 1989,
Page number
page 58, my lord, annexer 11,
58.
58, my lord. Amsar father, then my lord, Sirajul's name appeared at last, my lord.
Just a minute. In the writ proceeding, the petitioner relies on the voters list of 1965 of village Maleka Ding,
Malika.
which contains the name of Amsar Ali, son of Umaid at serial 257. Reference is also made to the voter 1989 of village Malika Ding, which contains the name of Amsar Ali, son of Umaid at serial 634, and that of Sirajul Islam, son of Amsar Ali at serial 641, and both are shown to be residing in the same house number 167. Accordingly, a prima facie case has been made out. Right.
My lord, in fact, it is our mistake, my lord, 65 brutalist. In translating the village, my lord, it is written as Malekadin. In fact, my lord, it is a Melekadin. Melekadin, my lord. A vernacular also shows that.
Spell
At page
Maleka.
20, Melekadin. In the
It will MALA likha ase to it will be MELA.
MEL.
MELE.
MEL.
Maleka koba. Maleka no, Maleka. Eka. You correct it
Develop.
also? Correct it in the.
My lord,
Item 8.
Okay. Notice it.
Let me say, my lord, the incoming order is at page number 43, but my lord, the total list of 1966 of the petitioner's father is
Page number
at page number 33, my lord.
33.
Munsar Ali is her father and Sahira Banu
Uh,
is her mother, my lord. And the link document,
Just a minute. 66. Village. Chor. What is Chor?
number 5.
2935 number Chor.
Yes, my lord.
There's no other name.
No, my lord, that is the name. 5 number, the next total list also, the next total is also 5 numbers.
Is there a village also named?
5 numbers, sir, my lord. that is-
Number 5 shore.
Yes, my lord, that is store area, my lord, and
I understand. How many such names will be there?
I have no idea, my lord.
Your villagers thought that let us name our village number 5 shore.
Yes, my lord.
Another villager of a different place may also have thought that let us also name our village number 5 shore. How will I differentiate the two? Oh, anyway, father is Monser,
Mansur Ali, yes, my lord, and mother is Sahira Banu.
mother is Saira, and
Well-
Sobana, which document is Sobana as the daughter?
Thereafter, my lord, link document, my lord, is at page number 42, my lord.
What kind of link you want to
My lord,
establish?
it is, my lord, Zuma, copy of Zuma Banu.
We don't want any link. We want which document or material will show that Sobana is the daughter of Monser.
That is the.
Page number?
Originally is at page number 42, my lord.
42.
Zuma Bandi. copy of
Jamabandi, okay. This is a land in which place?
Mohanpur part 2.
Sorry,
Mohanpur part 2.
Mohanpur and
Adjacent,
how will you prove?
my lord, adjacent village. And now the petitioner is also residing at Mohanpur, my lord. The number 5, so has.
Then how will
already
you
been
prove
eroded.
it? Mr. Your Talukdar,
Yes, yes.
Talukdar, how will you prove it? The petitioner may produce any relevant material which may show that Monser Ali of the 1966 voters list of number 5 Chor under police station of Bhayapuri had subsequently shifted to village Mohanpur part 2 so as to enable him to purchase land in the subsequent village.
His father is not no more alive, my lord. The other family member has already been.
That
shifted, my
the family member of so and so had shifted.
lord.
Just purchase land in another village, namely Mohanpur part 2. Just a minute.
That is the land of her mother, my lord.
And name of the mother.
Mother.
Mohanpur Mahon number Mati. Mr. Pine, the claim of shifting may be correct also. Because if you notice at page 42, you also examine this aspect. Mohanpur name is purchased in the name of Sahira Banu, who is the wife of, Monser. as per that voters list of number 5 short. So what he says that after his death, they shifted to another village, that may be right also. Otherwise, the mother will not purchase the land. Anyway, Mr. Talukdar, let's see what more you have.
Only voter, I
And,
can produce voter list only, my lord.
No, heavy korok. Where is the voters list?
My lord, that is at page number.
I
33, my
the
lord.
petitioner relies upon the voters list of 1966 of village 293-5 number Chor under police station of Bhayapuri, which contains a name of Monser Ali, son of Meher Ali at serial 84 and Sahira Banu, wife of Monser at serial 85, and both are shown to be residing in the same house number 30. This claim that later on, after death of Monser Ali, Sahira Banu and the children had shifted to village Mohanpur part 2, where they had purchased a plot of land in the name of Sahira Banu. The Jamabandi at page 42 of the writ petition reflects that the land had been mutated in the name of
The petitioner has her sister, my lord.
who is the petitioner? Sobura, in the name of Sobura Khatun,
Yes, my lord.
daughter of Monser Ali, in place of Sahera Banu. The petitioner claims that Sabura Khatun of the Jamabandi is the petitioner herself. In view of the above interview. The petitioner to also bring in relevant material to show that the family of Mansur Ali had shifted from village number 5 Chor to village Mohanpur Part 2 by producing any relevant material or document. Okay.
Interim protection.
You don't want.
I want
Interim to
to-
recall. Karo.
No, I want the
No.
interim protection.
Item 9.
Yes, Surya
Yes,
Banu, who is the father?
Father's name is Baksha, my lord.
Page number
Baksha Mia, my lord. Page 18, my lord.
18.
Baksha Ali. Her mother name is.
Baksha is
Nalbanu.
the father.
Yes,
Sokina mother.
grandmother,
Sokina is grandmother.
yes.
Baksha is the father. Okay.
Nalbanu mother, my lord.
Nalbanu mother. Santoshpur Part 2. And which document will show?
My
So
lord,
there is the
in this
daughter
case,
of
my lord,
Badsha Ali.
Yes, page 23, my lord.
43.
Page 23 in the same house, my lord, same house number, my lord. Here is Baksha Mia, Tahir, Lalbanu, and serial number 915,
Surya Banu is the
Surjo Bhanu Quddus Ali.
Santoshpur. Mr. Pine? Hmm. There are two Surya Banu. Which
Yes,
one?
my lord. One is sister-in-law, my lord. Husband name is Jalal Uddin.
Jamaluddin.
Jamaluddin. And 915 serial number, Surjo Bhanu Quddus Ali. And in this case, my lord, mother address.
Mr. Pine, they all reside in the same house. Surya Bhanu and Badsha Mia, they reside in the same house.
Let record come, but notice is not issued.
Husband no now. The husband lives in the house of the father-in-law.
My lord, that is the written statement, my lord.
Sorry.
In the written statement stated that the petitioner's father mother shifted to son-in-law's house, my lord. And as such, their name is Campiles.
Father-in-law shifted to son-in-law.
Yes, my lord.
Son-in-law did not shift to father-in-law. Same
As per
village.
written statement.
Hello? Yes, Mr. Payne.
Let the record come.
Interim, let you.
It's notice is not issued. It is first
Uh-huh.
time today.
No,
First time
no,
it is
notice the interim.
Yes.
Yes. In the writ petition, the petitioner relies on the voters list of 1966 of village Santoshpur Part 3, which contains the name Badsha Ali, son of Tahir, at serial 166, Sokina Bewa, wife of Tahir, at serial 167, and Lal Bhanu, wife of Badsha, at serial 168. Reliance is also placed on a voters list of 2008 of village Santoshpur Part 2, which contains the name of Badsha Mia, son of Tahir, at serial 911, Lal Bhanu, wife of Badsha Mia, at serial 912, Surya Bhanu, wife of Quddus Ali, at serial 915, Quddus Ali, son of Kadir Baksha, at serial 916, and all of them are shown to be residing in the same house number 197. It is stated that Surya Bhanu is the daughter of Badsha Mia, although she is the wife of Quddus Ali. And Quddus Ali of the serial number 916 is the husband of Surya Bhanu.
Obvious.
Item 10.
Yes.
May I please, your lordship? Petitioner is Manik Mullah, son of Fazal Mullah, whose name appears in the voter list of 2005, page 64, your lordship.
Whose name? Manik
Petitioner-
Mullah or Fazal Mullah?
Both their names.
Both names appear.
Yes, in
Where
the
does the name of Fazal Mullah appear?
for 2005, your lordship, voter list.
No,
page
2005 we understand. Where does the name of Fazal Mullah appear?
In the village, Dokhin Sitoli, your lordship.
We understand.
Yes.
2005 will not establish.
Yes,
his
your
affiliate.
lordship.
In a prior voters list, where does his name appear? Fazal Mullah.
In the voter list of 1989, your lordship.
89 is also not
Yes,
good
your
enough.
lordship. He who is the son of Wahed Ali and.
Okay, you are tracing from the grandfather.
Yes, your lordship.
Where is the grandfather?
Your
Which page?
lordship, page 64. 54, your lordship.
Page 64.
54, your lordship.
54.
Yes, your lordship. 54 and your lordship 55. Wahed Ali, your lordship. And Kajali baby is is the grandmother.
Oh, Wahed Ali is the grandfather.
Yes, your lordship.
Kajoli Bibi grandmother.
Yes, your lordship.
And who is the father?
Father.
Father is not there.
Is not there.
And just a minute. Village Dokhin Sitoli,
Yes, lordship.
house number 54. Now, where the name of the father appears? 89.
Your lordship name appears alone, your lordship, because prior to that, both the parents were died.
Understand?
But in
which-
Jamabandi of,
No, which page? You said 89,
Yes.
his name appears. Where is it?
yes, 89, your lordship, page 60, your lordship.
60.
Yes, your lordship.
Wahed Ali. Who is the father?
Your lordship, Fazal Mullah.
Fazal Mullah.
Yes.
He is the father.
Haliman Nesa is the mother.
Dokhin Sitoli, fine. Now, where is the name of Fazal Mullah and Manik Mullah appear together?
Your lordship, page 72 is the Jamabandi. 72, your lordship.
Jamabandi,
Yes, your lordship.
same village land?
Same village, your lordship. Number 3, your
Dokhin
lordship.
Sitoli,
Number 3, Patadar, Fazal Haq Mullah,
Fazal Haq.
your lordship.
And in his place, where is the, who is the petitioner? What is his name?
Petitioner is,
Manik.
Manik
Where is
Mullah.
Manik Mullah?
here it's not there, but with grandfather and father, Jamabandi is there.
No, that is understand. Where is Manik Mullah?
2005 voter list, page 64, 64, your lordship.
64.
Yes, your lordship.
Same village,
Same village, your lordship.
Sitoli.
Yes, your lordship. Dakhin Sitoli.
Yes, Mr. Sharma.
Yes, notice may go, otherwise.
In the written petition, Reliance is placed on the voters list of 1966 of village Dokhin Sitoli, which contains a name of Wahed Ali, son of Nawaz at serial 169 and that of Kajoli Bibi, wife of Wahed at serial 170. It is claimed that Wahed Ali is the grandfather of the petitioner. Reliance is also placed on the voters list of 1989 of village Dokhin Sitoli, which contains a name of Fazal Mullah, son of Wahed Ali Mullah at serial 162. It is claimed that Fazal Mullah is the father of the petitioner. Further reliance is placed on a voters list of 2005 of village Dokhin Sitoli, which contains a name of Fazal Mullah, son of Wahed at serial 243 and that of Manik Mullah, son of Fazal Mullah at serial 245. It is claimed that Manik Mullah of the 2005 voters list is the petitioner himself. And accordingly claims that burden under section 9 has been discharged. Prima facie case being made.
Item 11 for admission.
Yes, Mr.
Lordship, the grandfather.
Baby Begum Majumdar.
Baby Begum, the lordship,
Uh,
grandfather's name is State Lordship, 18 Lordship. Page 18 Lordship, Haris Ali Lordship. And the grandmother is Lalbi Bibi
66.
Lordship.
village Berenga. Horisali is the
Harusali is the grandfather, Lord.
Horisali grandfather,
Grandfather, Lord.
Lal Bibi grandmother.
Grandmother.
Okay,
And Lordship petitioner's father's name, page 28, Lordship.
28.
Rafiquddin.
Rafiq is the father.
Father. A mother is Lordship Rabia Begum, Lordship.
Name of the village.
Village Lordship,
Where is it stated? It is same village Berenga.
Lordship, subsequently.
Page 28.
Page 28, Lordship. It is the Silchar part 10, Lordship. Silchar part 10.
It is claimed that Horisali Loskar, son of Katumia Loskar, of the voters list of 1966 of village Berenga part 2 is the grandfather of the petitioner.
Lord.
And Rafiquddin, son of Horisali,
Father.
of the 1985 voters list of Silchar part 10 is the father. It is also claimed that the family of Horisali Loskar
Yes, sir.
had shifted from village Berenga part 2 to Silchar part
10.
10.
And there is another name is this Madhurban, Lordship. Silchar part 10, Lordship, it is revenue name, Lordship, village name, the
Very
Madhurban.
good. Where is the material to prove it?
In
The petitioner may provide any material which may prove that the shifting had taken place from the
Oberlin,
as a force.
to Islam. Okay.
Just after 2 weeks.
Item 12,
Yes, Mr. Borvia. Komolara Begum Loskar. Who is the father?
My lord, page 26.
26.
Voter list 1965. Serial number 287. Amannan. Amannan.
Hangmannan.
Amannan.
He
Mannan.
is the
Abdul
father.
Mannan, father.
Father. Amin,
Mother is Dulu Bibi.
Aminuddin mother.
Dulu Bibi is my mother.
Dulu Bibi is the mother. Who is Aminuddin?
Aminuddin shown brother Lordship,
Brother.
expired.
Now who is the petitioner? Komolara Begum. Which
Petitioner
document?
Komolara Begum is the daughter of Abdul Mannan. And your Lordship will find page 24. And exclusive will also annex page 24, one land mutation certificate.
You produced the,
And school certificate
no,
Lordship.
no, you produced the order of the circle officer.
Office authority provisional
See,
land mutation information that.
Mr. Borvia, this
Lordship.
is for information. We are not interested in any information.
Apart
You
from
produced the
Yes.
order passed by the circle officer in this mutation.
And one
The
school
petitioner
certificate
to
Lordship.
produce the,
If-
sorry, we can't,
Another aspect, school certificate is also there Lordship.
let
I
it
can-
remain there. This is
Yes.
a better document.
Page 18,
Mr. Borvia,
Lordship.
when we want the order of the circle officer, we want to verify it.
Lordship. Lordship.
The petitioner relies upon a provisional land mutation information under the signature of the assistant settlement officer that land pertaining to DAG number 102-104 of second RS Patta number 166 of Moser Nutan Ramnagar part 4 had been mutated in the name of Aminuddin Loskar, Jamaluddin Loskar, Saleh Ahmed Loskar, Tafazul Ali Loskar, and Kamal Ara Loskar, being the sons and daughters of deceased Abdul Mannan Loskar. The complete, the Jamabandi as well as the order of the circle officer by which such mutation orders were passed may be produced before the court. This is a better document for you.
Lordship.
Why are you going to some indirect method? Next.
Even inquiry
Next also
for
answer. Next item.
my voter list stated my
Item
father's name
13 for orders.
after. Three weeks.
Wait, let me see.
After 3 weeks.
You apply for that mutation order. Also apply for the certificate copy of the Jamabandi, get it? It will be you in a much better position than what you are now. Review. Notice had been issued.
Yes, my lord.
So today we are hearing
They
the
appeared,
review.
my lord, and they appeared and
Today are we hearing the
affidavit
review?
in apposition and affidavit in.
No, are we
reference.
hearing the review today?
My lord, it can be, my lord, if my other side.
Mr. Sharma, are you ready with the hearing?
Okay, I appeal on behalf on for respondent number 6, Lordship, private respondent.
Private
We
respondent.
have been implemented as a new party and we have filed our affidavit as well, Lordship.
Who is the respondent number 6? M.U. Mahmood advocate.
Advocate, Lordship.
Why is implemented by name?
My lord, here what happened, my lord? The learned counsel, Mr. Mahmood, submitted before the honorable court that he has been instructed to withdraw the writ petition, writ appeal. But exactly, my lord, there is no such instruction. So writ appeal was withdrawn, dismissed on withdrawal.
Against that
Subsequent-
review.
Well, Lord, I want that writ appeal may be hard on merit because
Mr. Sharma,
Appellate-
how will we prejudiced if we hear the claim on
my
merit?
lord, my lord,
Why again embarrass one learned counsel?
my lord.
No. The learned counsel maybe on a mistaken thought also may have said, or his statement may have been misunderstood by the court.
It's a happened, my lord. sometimes.
Everything is possible.
In the
Why
bench side, my
again
lord, sometimes,
proceed against the learned counsel, find out the truth,
my lord.
and ultimately the appeal was not heard on merit. Let us hear it on merit.
My lord. And my learned
Uh-huh.
counsel, my lord. Learned counsel of the opposite party, my lord, he also fairly submit that if relief granted by the honorable court, he has no objection. In the affidavit in opposition, that is the last stand taken by Mr. Mahmood.
By which order he was impleaded?
My lord,
By which order he was impleaded?
my lord.
By which order?
He was
The-
implemented, my lord.
As per the order dated just a minute, 29/4/2022. 29/4/20.
Four. My lord,
Just a minute.
4/1/2023. Implement is allowed.
IA. Who filed the IA?
My lord. I was filed by Abdul Kalam, my lord. Because, my lord, in the initial stage, my lord, in the review petition, he was not party. He
That's
was
what
not
we were
made
asking.
party,
No,
but honorable court insisted that he should be made party. Ultimately, Mr. Mahmood was made party. IA number 430 of 2021.
we recall the order.
Yes, Lord. Read appeal may be heard on merit.
And we don't go into this question.
Yes, Lord. Appeal may be heard on merit, Lord.
Heard Mr. M. A. Sheikh, then counsel for the petitioner, and heard Mr. G. Sharma, your name, please.
AK Boro on behalf of.
Also heard Mr. A. K. Boro on behalf of respondent number 6. Review petition 148/2019 has been instituted. Where is the order?
105, my lord.
105. Against the order dated 15/9/2017 in WA 157/2017. WA 157/2018 was instituted against the order dated 14/9/2015 of the learned single judge in WPC 811813/2010, by which the writ petition of the review petitioner herein assailing the order dated 6/11/2009 of the Foreigners Tribunal number 1 Morigao in case number FTC 619/2006 was dismissed. When WA so-and-so number 2D was heard on 15/9/2017, it was recorded that the learned counsel for the appellant submitted on instruction that the appellants did not want to press with the appeal, and accordingly the writ appeal stood dismissed. This review petition is instituted that there was some misunderstanding or miscommunication between the learned counsel who appeared for the review petitioner in the writ appeal, which led to the learned counsel making a submission before the court that there is an instruction not to press with this writ appeal. Be that as it may, it is the persistent stand of the review petitioner that the review petitioner was interested to have a consideration on merit in respect of WA so-and-so, and there was no intention on the part of the review petitioner to have the writ appeal stands dismissed on being not pressed. In view of such stand of the review petitioner, the order dated 15/9/2017 in WA 157/2017 is recorded, and WA so-and-so be listed on its own terms.
Item 14.
Next is also yours.
Malay.
Item 14,
Yes, my lord, mine.
same.
Yes, no, not same. It's with another aspect, my lord.
This is a review on merit.
My lord, what happened in this case? My writ petition was dismissed by your lordship. I filed a review petition.
Did I dismiss?
Yes,
I
that was
dismissed.
also dismissed.
I dismissed.
Yes, no, my lord. Concerning bands.
Okay.
Yes. So thereafter, what happened, my lord? The review petitioner went to Supreme Court.
Review writ petition dismissed.
Then review was dismissed,
Review also filed before the learned single judge dismissed. Went
And-
to Supreme Court.
Supreme Court, my lord,
Uh,
and the Supreme Court order at page 100.
100.
Yes, my lord.
What does it provide, Supreme Court?
Supreme Court said that permission is granted to file a fresh review petition before the
Fresh review petition
may be filed
before.
the Honorable Guwahati High Court.
That was the single bench.
My lord. At that time, that was single best. But now the furnace matter is taken by division bench, my lord. That problem is there. Because at this stage, my lord. no
What
court-
would have been,
It was withdrawn.
what would have been had it been reversed? Say at that time it was taken by the division bench, and now it is taken by the single bench. Then what would have happened?
It would go to single bench, my lord, then.
How can the single bench recall the order of the division bench?
No, my lord,
Suppose it had been reversed,
my lord,
that division bench had passed some order.
my lord.
Now we want a review. Now it will be single bench. Then what would have happened?
My lord, then single bench cannot. That
But
problem. will
division
be-
bench can.
But division bench can, my lord, it is a larger bench.
Where is the order to be recalled?
My lord.
Which page?
So, my lord,
Which page? Which
my lord,
order is to be
page
recalled?
27, my lord.
27. No, it's an order of the division bench only, not single bench.
Oh, my lord, I am sorry.
Ah.
No, my lord, review petition, yes, division bench. I am sorry, my lord.
So the court was of the view that in order to invoke writ jurisdiction for certiorari, a duty is cast on the petitioner to show that an error apparent on the face of the order is impregnated.
My lord.
If not, court cannot exercise its jurisdiction considering the writ petition to be an appeal against the order impugned. Now you submit.
My lord.
If you want this order to be recalled,
My lord.
now you have to make your submission.
My lord, that is why, my lord, being agreed by this order, my lord, I filed a review petition. Your lordship would be pleased to see the order of the review petition.
Page number.
My lord.
Number 84. 84.
54.
84. my lord.
84. Now you want a review of the review order.
My lord, because, my lord, I cannot. Generally, I cannot.
Not generally, you cannot.
I cannot.
There is a Supreme Court judgment on this. No review against
No,
review.
no. No, my lord, that is there. So, my lord.
Then how
while
do you want us to
Supreme Court-
exercise your power
while
now?
Supreme Court, my lord, while Supreme Court,
Supreme Court has not laid down any law. Just
well,
we
not
have read.
laid down, my lord, but thing is this, my lord, on our approach, Supreme Court said that,
Mr. Sheikh, we understand.
yes, my lord.
What it says, learned counsel for the petitioner seeks permission to withdraw with liberty to file fresh review petition.
Fresh review petition.
Liberty is granted.
My lord, yes.
Liberty
Next
is
sentence, my
granted
lord,
does not mean
permission as sought for is granted.
permission is granted, but
Yes,
this
sir.
is always subject to maintainability. Supreme Court has not issued any direction to the High Court that if review is filed, you hear it on merit.
No, but that is not said, but my humble submission will be,
Mr. Sheikh, I think you'll have to go to Supreme Court again.
my lord, 1 minute, my lord, if your lordship do not entertain, ultimately I am to go.
Because-
Your lordship would be pleased to see. Learned counsel appearing for the petitioner seeks permission to withdraw these petitions with liberty to file a fresh review petition before the High Court. So, my lord, that point was before the Honorable Supreme Court, that I want to file a fresh review petition. So, my lord, permission as sought for is granted, meaning thereby I am allowed to file a fresh review petition.
Till there, at that point, you are right.
Right, my lord. Now,
But beyond
accordingly,
that,
the-
you may not be right.
my lord, last
But
sentence,
beyond that,
last,
Mr. Sheikh,
my lord,
please come to terms. It's a very interesting legal issue. Till that point, you are right. Permission is granted.
permission is granted. Permission is
Permission
granted
is-
as sought for is granted.
Permission is always subject to maintainability of that permission.
My lord.
So we'll have to decide now whether the second review petition is maintainable or not under the law.
Well, on that point, my lord.
Because the Supreme Court had not decided the issue whether second review petition is maintainable or not. Suppose today I say, Mr. Sheikh comes and say, I want to go to Panbajar. We say yes, if you go. But if there is any restraint order of Mr. Sheikh going to Panbajar, we have not overturned that order. We have only, you say, well, I want to go, he said, you go. I have not adjudicated whether Mr. Sheikh can go to Panbajar or he cannot go to Panbajar. Nor I have adjudicated on the issue whether the restraint order of Mr. Sheikh of going to Panbajar, I have decided and overruled it. This is the meaning of the word permission. Suppose the Supreme Court would have heard this matter on merit. After hearing the merit says that this is the issue, go to the High Court and High Court will decide this issue. Then we'll entertain it without any further question. Here you ask for, I want to go there. Supreme Court does not even apply the mind whether you are entitled to go there or not entitled. You want to go, go. Now, when this is an order, we'll also now we will have to examine whether under the law it will be maintainable or not. Because I'll tell you the citation. There is a specific Supreme Court judgment that review against review is not maintainable. So now, if I entertain this review, I'll have to take a view contrary to that judgment of the Supreme Court. When we compare the two, one is a decided judgment of the Supreme Court, one is a permission granted. Of the two, which will prevail?
Generally,
Judgment will prevail. This is the difficulty you are in.
Well, may I submit something? May I submit something?
You have to submit within,
Well,
that submission must contain this answer.
my humble submission before.
Mr. Sheikh, we don't want a solution from you. What to be done? We want an answer to this. Can the High Court now, based upon the permission which was sought for granted, take a view different from a binding judgment? So you should have, whosoever appeared before the Supreme Court, he should have been more conscious of this situation. Sometimes what happens, suppose you directly go to the Supreme Court against the division bench order, file an appeal there. While moving the appeal, you say, yes, I don't want to press with this appeal, I want to try a review in the High Court. That review will be maintainable. Because under the law, otherwise review is maintainable, and Supreme Court has only permitted you. But in this circumstance, when you go, that I want to file a fresh review, Supreme Court says, go, fine. Supreme Court never adjudicated whether a second review is maintainable or not.
But this point I want to answer before your lordship.
Answer it.
Because my lord, when I asked for permission in the Supreme Court, the Supreme Court permission as sought for is granted. Supreme Court would have said, no, Mr. Sheikh, permission cannot be granted because
See,
secondary does not like-
when Supreme Court says permission cannot be granted, Supreme Court would have adjudicated on the matter.
Yes, my lord.
But Supreme Court, when without adjudicating granted the permission, had not adjudicated the issue. This is the difference.
My lord,
Now we are faced with another judgment of the Supreme Court. Why unnecessarily you complicated your matter? Who is this counsel? Some Shakil Ahmed, Parvez Dabar, Ujmi Jamil.
Shakil Ahmed, my lord.
He ought not to have done this. He ought to have known the law. Or he ought to have taken an adjudication from the Supreme Court that yes, I'm seeking this permission in spite of a judgment of the Supreme Court. Let there be an observation that in spite of that judgment, still you go and file a review as a one-time measure, we would have entertained it. Now, difficult for the High Court is we have to get over a barrier in the form of a judgment of the Supreme Court. We cannot do that.
So, my lord,
Supreme Court can do it.
my lord, I will grant it some time, my lord.
Yes, definitely.
1 month's time. my lord.
1 month time.
Yes, after 1 month it may come.
Yes.
Hello.
We expect some changes to be there. Within 1 month, you expect some changes to be there. Maybe.
Within 1 month, many changes are there.
Try your luck if you want change.
My lord. Even Honorable Supreme Court can bring some changes.
Wait for it.
Hello. Obligation.
Best course of this man would have been that I am making this prayer in spite of this judgment. Had the Supreme Court provided at least something, that in spite of that judgment, the High Court is permitted by or is allowed to go ahead, then we will have gone in. Now we'll be taking a view different from a judgment of the Supreme Court. It's very difficult for a High Court to do that.
Very poor lady, my lord, also went to the Supreme Court that this type of order has come.
But poor lady will not, a different set of law cannot be made applicable. That's a difficulty.
No way out.
A fundamental question has arisen in this review petition as to whether a review is maintainable against an earlier review order. Mr. M. A. Sheikh, learned counsel for the petitioner, refers to the order of the Supreme Court dated 24/2/2020 in I number 129454/2019. Which was a petition for condoning a delay, and I number 129455/2019, which was for exemption from filing OT. Wherein the learned counsel for the petition reference before the Supreme Court sought permission to withdraw the petitions with liberty to file fresh review petition before the High Court. And the Supreme Court provided that permission as sought for is granted. Now, a question would arise whether the said permission granted by the Supreme Court on a permission being sought for by the learned counsel for the petitioner appellant before the Supreme Court would enable the maintainability of a review petition against an earlier review order in view of the judgment of the Supreme Court rendered in the blank radio. Officer dealing head of mine. There is a specific judgment.
Obligation. It will be listed after 1 month.
As paid for list also ensure.
Item 15.
What is this?
I am allowed some modification of the order or something. I like to withdraw this item.
Want to withdraw?
Yes,
Withdraw the writ petition.
the petition of the dispose of matter.
You want to withdraw. I was for what purpose?
I filed the modification of the orders. You know, the honorable court directed to me to appear before the FRRO and register my name within 13 days, my lord.
Now you want some extension of time.
No, my lord. Already I have registered, my lord.
You already registered.
Registered.
Mr. F. A. Hassan, and counsel for the petitioner, states that as required by the order dated 26/4/2023 in WPC 2191/2023, the petitioner had already got her name registered before the Foreigners Regional Registering Authority of Borpeta. As the registration is already over, no further consideration is required in this interlocutory application, inasmuch as the introductory application was filed seeking extension of the time for registration.
Already registered, no?
I closed.
Item 16 for hearing.
May I please, your lordship. My lord, the petitioner is my lord Abdul Khalek, my lord, and in his name, my lord, he has his own voter list of 1970, my lord, from the same village where his
Petitioner Abdul Khalek. Who is the
Khalek.
father of Abdul Khalek?
father is my lord Ohad Ali alias Wahid Ali.
Page number.
My lord. Page number, my lord. 15, my lord,
Yeah.
and extra 3, my lord. Voter list of 1965, my lord.
65. Village
Kodamoni.
Kodomoni Pothar.
Right.
Ahid Ali is the father.
Yes, my lord.
And who is, and which document will show that Abdul Khalek is his son?
The next page, my lord, the page 17, my lord.
Page 17.
This is the voter list of 1970 of the petitioner himself, my lord. From
Page
same village, my lord.
Khalek, son of Ahid.
My lord.
Ahid.
1970 voter list. my lord. And the 1975 voter list are also there.
No, not required. If Khalek, who is the petitioner? Khalek.
Khalek is the petitioner.
You verify whether this Khalek and this present Khalek is same person.
My lord.
Heard Mr. Jed Hamad Land Counsel for the petitioner. No? Also heard so and so. The petitioner Abdul Khalek had been referred to the Foreigners Tribunal number
Second, my lord, Nogao.
number 2 Nogao for rendering an opinion as to whether he is a person who entered the state of Assam on or after 25/3/1971, resulting in registration of FT case number 1967/2011. The tribunal rendered an opinion dated 30/11/2017 declaring the petitioner to be a foreigner. Being aggrieved, this writ petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of 1965 of village Kodamoni Pathar, police station Dhing in the Nagaon or Morigao,
Nogao. my lord.
in the present Nagaon district, which contains the name of Ahid Ali, son of Jafar Sheikh at serial 375. Reliance is also placed on the voters list of 1970 of Kodamoni Pathar, which contains the name of A. Khalek, son of Ahid at serial 512. The petitioner claims that A. Khalek, son of Ahid of the voters list of 1970 of village Kodamoni Pathar is the petitioner himself. If A. Khalek of the 1970 voters list is the petitioner himself, the petitioner has discharged the burden under Section 9 of the Foreigners Act 1946 that he is a citizen, inasmuch as his own name appeared in the voters list of 1970. In view of the above, remanded back to the tribunal to examine as to whether A. Khalek, son of Ahid of the 1970 voters list of Kodamoni Pathar and the present writ petitioner Abdul Khalek are one and the same person.
My lord.
Upon doing the needful, a reason or date passed, respondents and Home Department may make their own verification and submit the report to the tribunal.
My lord, I live.
Item 17.
Item 17.
Yes, Lordship.
None appears for the petition when the matter is called, list again on subsequent call. If none appears, the group only shall follow.
18.
Yes, 18.
May I please, your lordship?
Zalimon Nessa, who is the father? Who is
Lordship,
the father?
Sorhab Ali.
Hmm?
Lordship,
Page number.
time. We want some time.
One time, your name,
Nekibut Zaman Azad.
sorry,
Nekibut Zaman Azad.
Nekib,
Nekibut Zaman Azad. On behalf of Air Shikdar,
what is your name?
Nekibut Zaman Azad.
Nekibur Zaman Azhar.
Adjourned on the prayer of Namtu Nikidibu.
Item 19.
Yes, madam.
Yes,
Fazila
Your
Khatun.
Lordship, my lord,
Nakibur Zaman
petitioner's
Azhar.
father's name is recorded in the
Page
voter
number?
list. 1965, my lord. that
Page
is
number?
Page 12, my lord. Father's name is Nobi Hussain, my lord.
Nobi Hussain, son of Jawan.
Daughter
Is
of
the-
my lord,
He is the father.
my lord,
Nobi Hussain is the father.
father, my lord.
Mhm.
Page 14 also, my lord, voter list of 1970, my lord.
Why 5 petitioners?
My lord's petitioners, she is a lady, petitioners number 225, my lord, the son and daughters, my lord.
Now, a reference is made against petitioner number 1 or against everyone?
My lord, I am.
The land counsel for the petitioner to verify from the records whether the reference had been made to the petitioner number 1, Musammat Fazila Khatun, wife of late Faziluddin, or it had been made in respect of all the 5 petitioners. List again next week.
Obliged.
Mhm. Would you- Where is she gone? Madam, yes, madam. Why did you make 2, 3, 4, 5 as the petitioners? Order to prohibit this in.
They are my lord, son and daughters, my lord.
Order is against all of them.
Notice 31. My lord,
There is some confusion. You see,
my lord,
the tribunal order says reference answered in affirmative against Fazila Khatun. What do you mean by affirmative? Citizen or foreigner? What do you mean by affirmative? Look at the order.
Means hereby foreigner lordship.
They will say affirmative means declared to be citizen, you will say declared to be foreigner. Let the tribunal explain what they had done.
Otherwise, reference is affirmative means lordship, he declared as foreigner lordship. Affirmative.
How do you word your reference? We word it in a whether a person who came after 25/3/1971.
Yes, lordship.
So you decided affirmative that the person came after 71.
Yes.
Tribunal notice reference to the caste this way. Anyway, you check up.
my lord, page 31 is the notice, my lord. Notice issued all the petitioners, my lord. Obliged.
You've seen the notice is to all the 5% against whom the reference was made,
My lord.
against whom the inquiry was made. I know that from the record.
Obliged.
Yeah, side of. Take the record, check up. Yes, next item.
Item 20,
Bindya Namasudra. Yes.
My lord, I am appearing on behalf of my senior advocate, BK Singh. My lord, it has first time listed for hearing and my senior is absent. So my lord, one of time may be granted.
That cannot be a reason. Matters are listed to be heard.
Yes, my lord.
There is no rule that it will be heard only on the second, third hearing, not on the first hearing. There's nothing like that. Every listing is a hearing. And not only listing in the hearing column, even if it is listed in any other orders to admission column, still it can be heard. If otherwise the matter is ready, there's nothing. Ask Mr. Singh to come. Or you pay a cost of 1,000 token cost.
My lord, actually, my senior is absent because of his outside matter, and he is attending one another matter in Itanagar branch. So, my lord.
The CPC con diokson, order 17 rule 6.
Likewise.
Read that. Please read the tick mark with red. No, read a little loud so that we can hear.
The fact that the pleader of a party is engaged in another court shall not be a ground for adjournment.
Then how can you grant an adjournment on that ground? Say some other ground. Tell your senior BK Singh, ask him to read this provision. Okay. And also ask him to tell the court on the next occasion, why did he instruct the junior counsel to make this submission, which is against the law? Huh? Take note of it. Tell the court has asked this question to your senior BK Singh, why he had embarrassed the junior counsel by asking to make a submission, which is contrary to a statutory provision. On your prayer, we are adjourning it today, but we want this answer from your senior on the next date. Okay. Next week. What date you want?
1 week.
1 week. Adjourn on the prayer of Dhanvantri to be listed again. But tell Mr. Singh, without this answer, we are not going to hear him further in this matter. First, he has to answer this question.
Nice.
Item 21 for motion.
Yes. motion.
Please, your lordship. My lord, notice was wrongly served to me, my lord. I am not the, my lord, addressing against whom the notice was issued, my lord. Kindly see page, my lord, 89, notice
Page 89.
89,
Mokale Ajam.
Mokale Azam. Notice was issued to one Akhtar Banu,
Page number
page
89.
89. my lord.
Do we have the photocopy? Photocopy the
My lord, 90 page.
90.
Page 90.
Who issued? Tribunal number 3.
3 Dhubri, Rajsingh, my lord.
Biporit Poikho Akhtar Banu.
Akhtar Banu. Care of
Care of
Amjul.
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 PS Mankachar.
Mankachar.
Gao Kothalbari.
Kathalbari.
And who is the petitioner?
Petitioner is the, my lord, Mokle Azam, wife of Anjul Haq, and village is Kathalbari.
Kathalbari.
My lord, kindly see, my lord, my school certificate.
And what is the stage of the proceeding?
Instead, my petitioner immediately file an application. Before the, my
And what
lord,
did the tribunal do? What did
tribunal reject that application.
Where is that
My
rejection
lord,
order?
kindly see page 95. MP note. In the meantime, inquiry was made.
The inquiry report of the referral authority under memo number, page 95, what I say, memo number so and so, dated 16/9/2022, be produced before the court. Further proceeding against Mokale Azam, the writ petitioner, before the Foreigners Tribunal. Which Foreigners Tribunal? Before the Foreigners Tribunal number 3, Dhubri shall remain state until further orders. This form so and so. We are not issuing notice, just produce it. They say, you say it's the same person.
Yes, Lordship.
If it's the same person, why don't you issue notice to this person?
Yes.
Why do you issue notice in the name of another person? And actually, are they the same person?
No, my lord, even reference is made Akhtar Banu,
Akhtar Banu is another person.
and another person.
You know that person?
No, my lord. Even I do not know, even.
No,
place
no,
reference.
they say
My-
Mokale Alam and Akhtar Banu are the same person.
No, my lord. Yes, they said, but
They
I'm not that person, my lord.
So let us see the inquiry report. Stay.
I can prove myself as Mokale Azam, not as Akhtar Banu, my lord.
Timing item one.
Next week, we will.
Not right.
Not on night.
I-
Ninth, ask them to produce this inquiry report, whatever it is. Because tribunal says there is an inquiry report. Let us see what inquiry report, who had inquired.
Highly obliged, your lordship.
Item one.
One minute, may I pray for day after tomorrow, my lord? John to be listed day after tomorrow on the prayer Mr. Deepak. Sometimes, Mr. Buying, what happens, you know? Certain acts of some of the tribunals gives an impression of desperation. That should not be.
I have seen, my lord, it's
Ah,
complete mistake.
They are put in place to make a judicial adjudication.
Definitely.
Somebody's vital rights are involved, mind you. Even they are not on a mission. They are on a, although it's a quasi-judicial authority, their function is basically judicial, decided judicially. Why you try to give the impression that you are on a mission? Then what happens, you know, the credibility is lowered. Once the credibility is lowered, even the good order sometimes may be interpreted to be bad. But if your credibility is very, very high, and there's a great respect for these tribunals of any other judicial authority, then if they pass any order, that will be very carefully, that will be looked into.
Oh, your lordship.
With a background that the tribunal may be right.
Yes.
But because of this act, it's always the reverse. So they are lowering their own credibility. So we wanted to know some orders where they have declared to be citizens. Where are they?
Yes, my lord. I have collected, my lord. I will submit.
Let us see a few of them.
Not now, my lord. I will submit, your lordship.
When?
Within 2-3 days, I will submit. I have
2-3
asked them to
days.
collect, my lord. They are collecting money.
Huh.
They are collecting. It will
So
be-
if this is the method adopted to declare somebody to be foreigner,
This is, my lord, absolutely wrong, my lord. I have
we
asked
are
them.
also interested to know what method is adopted to declare somebody to be a citizen.
Yes.
Even if that method is also horribly wrong, then something serious is happening. Okay.
Item one for admission.
Please, Your Lordship. In this case,
That the more Jews.
yes, Lordship.
Last week, Supreme Court has passed some order.
Yes, Lord,
You got it?
yes. On May 18th.
Something like that. We didn't know.
few days back.
For whom do you appear?
On 30th of January, anywhere else more than
Sorry.
my lord, on 30th of January, Animal Welfare Board of India and Ministry of Environmental Forest, my lord, newly implemented. My lord, my lord, on 6th of February, for email, my lord, I have sent the, my lord, court's order, my lord, along with the requisition and all annexed.
So what do you want? Time.
My lord, I have not received any instruction, my lord, in this.
So
regard.
you are seeking adjournment to file affidavit or something.
But regarding, yet not received any instruction, my lord. Otherwise, my lord,
Have you gone through this order?
Yes, Lordship.
What does it prohibit?
The ban on Jallikattu has been lifted and the Honorable Supreme Court has in fact legalized that event. And Lordship will come to para 21.
21. Where is Mr. Talukdar? I think Talukdar appeared for the state, I think.
Yes, Lordship. There was an argument made whether the animals have rights. Then to legalize for legalize. Okay. Nine. Para 23. Recognizing the rights of animals. Para 24 on the question of conferring fundamental rights of animal on the animals. And para 40 is the reasoning of the court.
What was the earlier judgment? Same, same animal board. Earlier one, earlier Jalikuti judgment.
2014
That one.
That was specifically related to the event of Jallikattu.
Understand?
And
No. What is the name of the parties in that one?
that was Animal Welfare Board.
Same
of India
Animal Welfare Board.
versus A. Nagaraj.
Is this a continuation of that one, or this is a different petition? Because this one is also Animal Welfare Board.
Yes, Lord.
So the earlier matter had been referred to larger bench.
Larger bench.
Earlier matter had been referred to larger bench.
Yes, Lord.
And this is the VOD larger bench.
Yes, Lord. This is the 5-judge bench.
Yes, very easy.
Yes, my lord, I have not gone through this.
No, you have no.
Regarding, my lord, I.
Talukdar appeared for the state government earlier,
Yes, my lord.
and he heavily relied on the earlier judgment.
My lord, yes.
So that judgment has gone a change by now.
Earlier, RK Talukdar appeared.
Vijay Talukdar.
Vijay Talukdar.
Or somebody else is appearing. He will appear. Are you aware of the proceeding, what happened earlier and what is going to happen now? Then mere presence may not be sufficient.
2016 case. Earlier, there is a ban regarding Jallikattu. The recent judgment here, more online. On 18/5/2023, legalizing that Jallikattu.
Is he available or not, Mr. Talukdar? Because this is a same continuous hearing. So if you don't have the same learned counsel, the continuity is broken because
He's there. I think he has not been informed.
the other counsel is not aware of what had happened.
He's here.
And why particularly we need him? Mr. Talukdar heavily relied on that earlier Jallikattu judgment, referring to certain paragraphs that what is prayed for in this writ petition cannot be allowed.
He's available.
Now, the same thing a larger bench of the Supreme Court had considered. So we'll have to put it across him. And secondly, but whether the larger bench to what extent deferred or diluted the earlier provision. Especially the paragraphs relied upon by Mr. Talukdar. What is the effect on those paragraphs? So we'll have to hear both the parties on this issue and then pass around.
Take it after just.
After some time. Just wait for some time.
Item 2.
Itu dia tahu dia tadi kok. But that double tick,
Yes.
who had done it?
My lord,
Who had given those double ticks?
a report has come, my lords, may kindly have a look. at it. In the report, my lord, the person who conducted the report did not get all the records. They say it's a whole matter, records, all the records are missing.
No.
But
What you remember of this matter, Mr. Goswami's client had appeared in some examination
Yeah.
for some
Sub-inspector.
for some recruitment.
Yeah.
His allegation is that in his answer script, there were certain double tick marks. And he says, I did not give the double tick
Yeah.
mark. He had given one single tick mark. He may be right, he may be wrong in his answer, but I did not give any double tick mark. So now the question is, who had given the double tick mark if the petitioner had not done so?
Yes.
That means once the answer script is submitted, there must be manipulation by somebody else. If-
The report has come.
What does the report say?
Report says at least he has not done it.
He had not done
He has
it.
not done it. That much is there in the report.
Uh-huh.
Lords, may kindly have a look, just two paragraphs.
But the correspondingly, who is the beneficiary that
There
could
they
not be
couldn't
there?
find out. In fact, my lord, the answer keys were given to persons to examine. And the authority doesn't know to whom it was given.
To which examiner it was given?
Some unknown persons, and that thing is in mess, my lord. The report has come.
So you give him the employment. What else to do? We'll close the matter. Either you create a post or you.
But only one thing it says, the report towards the end says,
Because why we needed this inquiry, Mr. Mojumdar,
my lord,
if he had genuinely submitted his answer script, let us presume that on the basis of that answer script, he would have been selected.
Right.
Somebody later on manipulated by giving 2 tick marks, meaning thereby that that answer now will be rejected. So he will not be selected. When these are competitive examination for certain job and everybody had been appointed, meaning thereby that this manipulation was done by somebody, maybe within the department or outside the department,
Which you lordship observed in the beginning.
Ah,
Some got
to-
benefit also.
to favor somebody else who otherwise would not have got it. Otherwise, there is no requirement of any departmental authority to manipulate any answer script. So now one unscrupulous person will be in employment and you cannot find out who it is.
Lordship, kindly have a look at the report, my lord. I have submitted.
So 2 options are open now.
Yes.
We-
No, but in-
we-
In the report, my lord, it says that
Hmm.
his total marks will be minus the double tick marking, 106.5 marks.
Anyway, he would not have got it.
My lord, this is what I am saying. I do not know.
So now by manipulating his answer, you have given him a benefit now.
They have admitted there is no answer.
No, meaning thereby you have given him the benefit.
No, if his total comes to 106, then the person who was in the select list last,
Last.
he got 132 or something,
126.
126.
26.
Whether he will.
So even if you take the tick, double tick to be correct, still he gets 106.
106.
Still he
Accord-
gets 106 only.
According to the report.
According to me, my lord, I should get 132.
According to,
Me.
how will you answer this question? How will we answer this question? Not you. You have given your answer, he has given his answer. How will we
I
answer
have
it?
given, I mentioned the numbers also, everything.
And the answer scripts are not available.
His answer key person is available because original was called for, original is with the, again submitted to them for input.
We'll hear you, we'll think about what is to be done. Cannot be attributed by the petitioner.
That
This,
is-
this is very clear.
This is mentioned.
So if it cannot be attributed to the petitioner, must be somebody else had done it. So moment somebody else had done it, he gets a benefit.
Only one thing possibly, my lord,
Or maybe it can be construed the other way around. That he is a man who on merit otherwise would not have got it. So somebody comes and gives 2 double ticks so that his paper is manipulated. You go to the court will give you a direction to get appointed. That is also possible to help him.
2008, my lord,
2000?
the advertisement came out in 2008. I don't think, my lord, that they can visualize such a situation. Because there are a lot of
Unless-
answers, there are other cases, my lord.
unless the advice goes from my learned friend, my lord.
No, I didn't know him then. This case is of 2017.
Mr. Goswami is an astute lawyer. We know.
That is why, that is what
He
I'm
can
saying.
foresee many things.
Yes, yes.
But 2017, my lord. That is the time I have.
But what to do? Today we adjourn, we take note, you look at the
Yes.
report. You think what is to be done, but once it is an admitted position, his answer script was
Well, I'm
manipulated
furnished a copy of the report.
by somebody else. I think he entitled to some benefit.
Let the matter be heard on a particular day. Let him also go through the report.
The report of the CID Assam has been placed on record before the court. A copy thereof had been served on the learned counsel for the petitioners. List again also for a hearing of the matter. So next 15 June, you voted.
Okay,
I say.
15 June. 15 June.
15 June.
Much
Otherwise, you think what can be done?
What?
We have to pass some order.
Some. Let my land friend go through it, whether he can recall something.
After what has fallen from his kind of, is a Mazumdar, I don't think I need to go to that one.
No, whatever is there in the
They're not
report,
there.
I cannot, they have conducted the report.
Exactly. That's correct.
Means at with that position, he had manipulation, he is not a party.
He has not done. They could find out that it was done by some other person.
Hmm.
I'll take leave, madam. Matter is coming up before the interview. Much obliged.
Item 3.
Yes, Mr. Talukder. We do not expect you to remain till the end of the list. So,
It escaped my notice with.
that Jallikattu thing, you argued on the basis of the earlier Supreme Court
Earlier.
judgment. Some paragraph 42 or something,
Some
I have
paragraph.
taken note, some paragraph you have relied on.
Right.
Now the larger bench of the Supreme Court has come on the same aspect. Last week one judgment was delivered by the Supreme Court. So you read both the judgments, whether the provisions of the earlier judgment had been diluted or differed in any manner by the larger bench.
Right.
If it is differed, we have to follow the larger bench now. If it is not differed, only on some other facts, the larger bench decided in a different manner. Tell us, we'll hear the matter.
Any other day?
15 June next.
15 June.
15 June, we intend to sit once again first.
Right, ma'am.
MS B. Chaudhary, and counsel for the petitioner, has produced the judgment of the Supreme Court rendered in Animal
Welfare Board
Board of
India.
India.
Welfare Board of India and others versus Union of India and others of the five-judge constitution bench dated 18/5/2023. Mr. B.J. Talukder, learned counsel for the Senior Counsel for the state respondents, take note of the said judgment of Supreme Court and prays for an adjournment to examine the aspect of the implication of the subsequent judgment of the Supreme Court over the earlier judgment, which was relied by the states, by the state.
Because my lord, the impugned order at page 35-36 also makes reference to the earlier Animal Welfare Board of India judgment. So,
Madam Chaudhary, let him read, because two possibilities are there.
yes, lordship.
Larger bench may have gone on a total different direction, provided for something, keeping the earlier paragraphs relied upon by Mr. Talukder to be untouched
Lord.
or upholding it. Then those paragraphs will still have relevance. Or the larger bench may have totally diluted and differed from those views. Then the larger bench will prevail. And that it has to be to his satisfaction,
I'll go through the.
because it is his argument.
Right.
Item 3.
Yes, Madam Bora. Matter stands adjourned, stated by the other person. You were appearing, or Mr. RKB Chaudhary? Earlier, I think he appeared.
Let's say Once
because,
he has appeared, lordship.
uh,
Once he has appeared, lordship.
no, some, he
On
had,
a reading entry, lordship.
he had made some submissions.
Yes,
How to read the Redding entries.
lordship.
He had made a submission that if a person is proceeded under the law, some conviction or some adverse order is passed,
Lordship,
that will result in one Redding entry.
yes.
If this happens for 4 times, it is 4 Redding entries. Otherwise, by virtue of those orders in the proceeding, a person may not be dismissed from service. He may be given any kind of a lighter punishment.
Yes,
But if there is a cumulation of 4 Redding entries, maybe of 4 minor offenses also, the 4th Redding entry will result in termination of service.
that's what I said.
This is what Mr. Chaudhary
Yes.
had submitted on the earlier day.
Lordship.
Your submission is that a 3rd and 4th Redding entry, before it being entered, due procedure was not followed. Now, please submit which procedure was not followed. Where is the procedure and which procedure was not followed?
My lord, in this case, my lord, Assam Rifle Rule 2010 is followed, my lord. In my affidavit in reply, my lord, I have given the procedure.
No, no, please produce the procedure. Say that this is the procedure for the 3rd and 4th Redding entry and this was not followed. Let us see the procedure.
And my lord, I have submitted one Supreme Court judgment also.
Madam, please answer first, then you go to the Supreme Court judgment. Which procedure you were referring to that was not followed?
Yes, my lord. I have already annexed, my lord. Rule 2010, my lord. Assam Rifle Rule 2010.
Sorry?
Assam Rifle Rule 2010, my lord. Here, section 47. 48.
Where will you get this provision?
My lord, I have annexed the portion in my.
You have annexed in your affidavit. Which
in-
page?
In reply,
Page number?
but it starts from page annexer 1, page 54. Running page.
This one, Assam Rifles, these rules may be called Assam Rifle rules. Yes, which rule was not followed?
My lord, kindly see hearing of SARS.
Page number?
55,
50,
5,
rule 55 was not followed.
55 page number, my lord, rule 47.
The rule
hearing of-
47, hearing of charge,
Yes,
every
sir.
charge. This is regarding charge. Every charge against a person subject to the act shall be heard by the commandant in presence of the accused, and the proceeding shall be reduced to writing in the form set out in Appendix 5. This is not regarding Redding entry. This is regarding the regular proceeding that may be initiated, resulting in some kind of a penal order. For that proceeding, 47 is applicable. Because Redding entry as such has no procedure. Redding entry is only the result of a particular proceeding.
But-
If we understood it rightly.
Yes, my lord.
If there is one proceeding against a man that he had done the most simplest of the offense also, and that results in some penal order, correspondingly, there will be one Redding entry. Second proceeding, second penal order, second Redding entry.
Yes, my lord.
Same with 3rd and 4th. Now you say the procedure for Redding entry was not followed. There is no procedure for Redding entry. Once there is a proceeding, there is a penal order, automatically one Redding entry comes in. Not automatically, correspondingly, one reading entry comes in. 47 is regarding the procedure to be adopted in that proceeding.
Yes, my lord.
So meaning thereby, you have to challenge that order in the proceeding, not the reading entry, but that order.
Yes, my lord.
Have you challenged it?
My lord, there.
Where is your prayer? Let us see.
Is 9 of my petition.
This is this court martial?
No, no.
What is it?
The offense was summarily
Hey,
disposed,
very
Lordship.
good. Margaret,
And
court
against
martial,
this-
court martial division bench will be better decision. No, all court martial give a division bench. I think last week also. Quashing the impugn warning order as well as tentative charge sheet to remove see, reading entry cannot be removed. Have you understood what I'm trying to tell you? Reading entry is only the result of a
Yes.
particular penal order in a
Lordship.
regular proceeding. See whether this bench can take up. Mr. Nair, I think you represent the High Court also.
Yes.
So please take a look. This is a man of the BSF,
Assam, no.
Assam Rifles. Okay.
And this
Court
is-
martial of defense.
No, read the whole thing.
Honorable Chief Justice, pleased to direct that henceforth any writ petition pertaining to court martial of defense personnel and armed forces shall be
Armed
listed-
forces.
and armed forces.
Uh-huh.
Yes, man.
I
Shall be
think
listed.
Assam Rifles will be armed force at
Armed
least.
forces. Will be armed forces. Para, it's a para.
So this has to go
CAPF.
to the division bench or?
But if it is a martial, court martial proceedings, I don't think so. It's a court martial proceeding.
No,
Is it
first,
summary?
just take up the petition, what it is.
It is a summary disposal, Lordship. Yeah.
So if you summarily do it, single bench. If you do it court martial, division bench. Is it like that?
Maybe Lordship. It is specifically
Maybe
stated
foreign-
about court martial.
Mhm.
It is specifically stated about court martial, but in here, Lordship, the.
Court
search-
martial word is used in a broader sense or in a specific technical sense.
Court martial proceedings, my lord, should be in that technical sense only, my lord. because
Technical sense or in the broader sense. Everything is court martial when it is of the armed forces.
They
Only
have a
thing
summary
there
proceeding also.
is a technical differentiation. Some are called court martial per se, some are called summary, some are called force court.
But there is a convening of a court everywhere, my lord.
Huh.
But here, my lord, that stage has not reached, I suppose, my lord, because after page 36, the.
No, first
consequential-
prayer is quashing the warning dated 3/6/2015. Which page it is?
Page, my lord,
Uh,
my lord would come to page 36.
Page, no,
36.
3/6/2015, which page?
My lord, page, that is 36, my lord.
36.
All are given there.
6. You are enrolled as so and so on some records. Since then, your service into Edward 21 days. You have till date incurred 3 reading entries.
In our year to say the details of it.
Uh-huh. It is clear from the above that in spite of having advised many times to improve your conduct, you did not show any improvement. You are hereby warned to be more careful in the conduct. If you incurred the fourth, this is nothing illegal about this one.
So
They have very fairly told you
that fourth June.
that 3 reading entries is already over. In case you incur the 4th reading entry, you will be terminated. So,
Court already, lordship.
this is in the nature of a complying with natural justice itself. That instead of taking you by surprise, they have forewarned you. As well as the tentative charge sheet dated 13/1/2015. Which page?
Lordship, he has already got the court rating entry. 24, but it is not included in the service record due to pendency of this repetition.
24 page.
No. Fourth reading, reading entry must be pursuant to the charge sheet dated 13/1/2015. If that is already challenged, how can you complete and now take that stand?
So that was not, they have not challenged the court rating entry.
Madam Devi. They have challenged the warning letter.
Warning letter, lordship.
Warning letter says you have already got 3.
Yes,
If you incur the 4th, you'll be terminated.
lordship.
Okay. They have also challenged one charge sheet dated 13/1/2015.
Lordship.
Perhaps the 4th reading entry is pursuant to that charge sheet.
Lordship.
So once that is under challenge before the court, was it prudent for you to complete the thing and then say 4th reading entry has come, everything is infructuous? Are you not trying to overreach the system?
Lordship.
Where is the 13/1/2015?
Page 29.
Page 20,
Nine.
29,
No.
not 29. So there is an interim order. After hearing the council, it directed that those steps shall be taken by the respondents for discharge of the petitioner from service
Hello,
until further orders.
he's continuing and he petitioner is in service, my lord.
He is in service.
And in 2008.
So we'll have to decide the validity of the charge sheet dated 13/1/2015.
Lordship.
Which page is it?
Page 24.
24. 24. In that he was found absent. So this is the charge sheet
Lordship, lordship.
found absent.
Yes.
So why should we interfere with this charge sheet?
My lord, this is not in my writ petition, I have clearly stated that, my lord, on personnel, my lord, Bruce, I have been, my lord, 3rd and 4th was given because I refused to pass a false message of the CO.
Madam,
That
it is
is the-
nothing like that. You are totally misconceived of the provisions of the law. You means your petitioner. If you go by page 29, I think. If you go by page 29, not 29, 36. There are already 3 punishments against this man.
Yes,
3 punishments corresponding to them 3 rating entries. By this letter, they have warned you that if you incur the 4th one, you'll have to leave the service. You'll be discharged from service. Very well. We don't find any illegality in this letter. They are very fair, in fact. You also challenge page 24. Charge sheet. What is the charge? You remain absent. On what ground are you challenging?
my lord, this is false, my lord, this is
False.
false.
Who will prove it? Whether the charge of remaining absent is false or right, correct, who is going to prove it? High Court? Sorry,
I have.
it
to
will be proved only in that whatever proceeding was drawn up pursuant to that charge sheet. You go and answer that proceeding. If you can prove that you were not absent,
Yes.
in spite of that, they pass an adverse order against you, come back to the court, challenge it. If you cannot prove, means you were absent, they can pass any order against you. And where is the scope of the High Court interfering in this situation? This is your first prayer. What about the second prayer? Direction not to take any disciplinary action against directed by in the letter dated 3/6/2015. That is warning letter. How can any court of law pass an order that don't take a disciplinary action against this man? Is it possible? Is it? No. Second prayer goes. Third prayer. Direction in the nature of prohibition. So it's a writ of prohibition. What is a writ of prohibition? We know certiorari, we know mandamus, we know habeas corpus. Now, what is a writ of prohibition? What is a fourth prayer? Cognizance of punishment entries awarded the petitioner and so and so. As the same is without court of inquiry. So you are challenging 1/5/2014 and 13/1/2015. Where are they? Which page? Which page do we find 1/5/2014 and 13/1/2015 is that charge sheet. What about 1/5/2014? Your 13/1/2015 is not an entry. It is only a charge sheet.
Allegation. It's an allegation.
And the charge sheet can be interfered if a bare reading of the charge sheet does not disclose any offense. Here the allegation is you remained absent. So it discloses an offense. Whether you are actually absent or not is another factor that will be determined in the inquiry. So 13/1/2015 cannot be interfered. What about 1/5/2014? Which page? Have you annexed it? One, 5/2014. 1/5/2014 is not annexed.
He's relying on that page 36.
Page?
No, 36, last page. That notice given.
1/5/2014, where is the date? Okay.
Oh, 1/5/14.
In that severe reprimand on so and so, there is a rifle is unauthorized possession of 30 liters of diesel belonging to government with malafide intention. Why should it be interfered? We can interfere with this one only when you make out the case that some procedural law was not followed. And for that, you'll need that order to be annexed. then we would have called for the records of that proceeding and verified. So we close this proceeding. We'll give you liberty to challenge 1/5/2014 if so advised. Challenge it separately, get the order, challenge it. Okay. And the charge sheet, we cannot interfere. No ground has been made out. The warning letter of the 3 reading entries also we cannot interfere, because if there are 3 punishments, 3 reading entries, it's a natural consequence. Prohibition, writ of prohibition is not maintainable. And if you are aggrieved by any further order passed pursuant to that charge sheet, you come in a fresh writ petition. We'll entertain you.
Well, one thing, in 2018, he has completed 30 years and his service has been reviewed up to the age of superannuation.
Sorry.
And, up to the age of superannuation, his service has been reviewed in 2018 when he has completed 30 years of qualifying. service.
So
So I have.
So what will happen? Suppose you completed 30 years, what will happen? Are you entitled to something?
Review.
Pension, my lord.
Sorry,
He completes 25 years, they get an additional 5 years. So my lord, if he is retired, so my lord, he gets that pension high,
so if he
Get a higher-
retires at 30 years, he'll get higher.
higher pension.
Now he is discharged at 25.
No, he is, I think, completed 13.
30 in 2018, he has completed.
So you entitled to some more pension.
But if he.
Well,
this
how can
order-
you raise that issue in the writ petition of 2015?
Because my lord, this order stands, then he'll be terminated, so he'll not be entitled to any pension.
My grievance is that 3rd and 4th, that is without any inquiry, my lord.
Madam
was given.
Bora, you are again back to square one. Your mere saying is not good enough.
I have, in my repetition, I have said all.
You may have stated many
Yes.
number of things in your writ petition, but
And
that will not change the nature of your case. Firstly, you have challenged one warning letter containing 3 reading entries, which is factually correct. You have challenged one charge sheet, which we cannot interfere in a writ proceeding without any rhyme and reason. You have challenged one order of punishment of 1/5/2014 without even bringing that on record. For 1/5/2014, we allow you to challenge it. We'll give you liberty. Warning, we cannot interfere. Charge sheet, we cannot interfere. But if the charge sheet has been carried forward and there is some adverse order against you, we'll give you the liberty to challenge that also. If you succeed in that, the 2 reading entries will go, 3rd and 4th. If you cannot succeed, it will remain. Reading entries are not a separate order of punishment or something that is given. That is the consequence of a order of punishment, which is passed in a different proceeding. Think over, come back at 2, it's already 1:15. And we don't find any other merit in your matter.
And may I take for some other day, fix that, my lord.
Today, fixed at 2 o'clock, there is a 45 minutes to think over. We have nothing in your case, what to do? Only window we can foresee for you is if the charge sheet resulted in an order of punishment, you challenge that proceeding. If you want to challenge the earlier order of punishment of 1/5/2014, challenge it directly. Then we can call for the records of that proceeding and verify whether procedure was followed or not. We cannot help you beyond that. For both the purpose, liberty will remain.
I look at it. I've asked her to just go through it once, my lord, at 2
Just,
o'clock.
yeah,
I said, At 2 o'clock time is there.
We don't see anything beyond this. What else to do? We
Red
can't
and green.
pass our orders in a random manner that just because you want to pass in favor of somebody, you pass it.
My lord,
Can't be like that. There's some
411.
reasoning also why we pass our orders.
My lord, can I have one indulgence? My lord?
You have one matter we have
No,
seen.
4 and 5, my lord. If not otherwise, my lord is sitting on 15, my lord. If lordship can have it on 15, because in 4, I have got my instruction. 15, my lord, will take some time. Other 5, item number 5, we will do it on 15.
4 and 5.
No, 4.
Mr. K.R. Pangiri, you are interested to do your matter?
This is also Lordship.
That force court and that one. Are you ready
4 and
today?
5.
Lordship, whether as per this,
No, only thing we find is the force court is a little truncated procedure. The complete court martial or whatever you call it is a complete procedure. And this man was,
Constable, my lord.
sorry, constable. Huh. So just because it is constable, does it mean that you will only conduct a summary proceeding?
Lordship, in the summary force court Lordship, the procedure is duly followed.
Madam Devi, you have been saying that for the last, I think this,
Yes, Lordship.
how many days we heard this matter, we don't know. Every day you repeat the same line.
If he pleads the guilty, then procedure is different. If not plead guilty, then the detailed procedure
Sorry,
has been.
we are,
followed,
I think, set one question. Either you answer that or you take it that you don't have the answer and we'll pass our order against you.
Lordship. From-
Don't repeat the same
Yes,
thing.
Lordship. From 135, ruled 135, it is detailed
Yeah,
procedure has been.
stated
given,
that on many number of occasions,
Sure.
same line. And one officer also came,
Yes,
accompanied you on the last several days. And we put a specific question. And we want an answer to that.
Lordship, he has pleaded.
Without repeating
Lordship.
what was considered to be insufficient on the earlier dates, answer that question, whatever was said. If not today, you take an adjournment. If you want to do it today, do it. But also, we should not go on adjourning also now. Especially Padhat matters should not be adjourned.
Lordship.
We'll hear you then. That is how we file to. You had a question set for you. But item 7. Mhm. Yeah, order of 14/3/2023. Where charges are serious, can you do it or not? This is the question we raised. We have to answer it. Constable, yes. If anybody is constable or below, answer is yes. But when the charges are serious, what is the charge against you?
He fired 6 rounds. Lordship.
Sorry,
He fired 6 rounds.
fired 6 rounds. That's a serious charge.
Yes.
It may lead to a conviction of section 307 also. Somebody died.
No, my lord, no, my lord. In the open fire.
Open.
Yeah.
So that may be a case of 307 also. Even if you start firing, that's a serious charge. So whenever it is a serious charge, having implications of the Indian Penal Code, what kind of procedure should be followed? Merely because a man is constable, just do a summary proceeding, will it be sufficient?
And also he has pleaded guilty. And also in the appeal also, the
Pleaded guilty.
guilt, yes, Lordship.
No, my
Yeah, there is a proceeding wherein he has pleaded guilty.
We'll hear you today.
Lordship.
But we don't think a summary proceeding should be allowed for serious charges. Had it been 203, 302, what would have happened?
Lordship.
And in fact, this question we have already raised in one of the proceedings. Does these commanding officers have any knowledge? Intricate knowledge of the criminal law of 302 or 307, etc. Do they have any knowledge?
302, in that case, general court martial.
Even general court,
Yes.
we have already set a question why these proceedings should not go to the regular criminal court.
There is.
Because
certain-
your commandants, see, a regular criminal court is manned by a district judge, session judge.
That's it.
What is the qualification? What is the experience? What is the eligibility? Why? Because these laws are having complicated laws having its own implications. If it is a service matter, it is okay, you dismiss a man. That's not much of a concern. But you'll be giving him life sentence, you'll be giving him death sentence. So does a commandant of a battalion have any rudimentary knowledge of those laws to decide whether somebody has committed a 302 or 307 offense? There's a difference between taking disciplinary action and passing orders of conviction. So whenever it's a case of a serious offense under the Indian Penal Code, we have raised the question, you have to answer it now. If everything is given to a commandant, and here is a case even worse, give it to a summary proceeding. So what is summary proceeding? Yes, come over, sit here. Have you done it? Yes. Conviction. You are now sentenced to so and so. Does any criminal law jurisprudence is in support of that? Is the Army Act and the BSF Act not required to be read along with the criminal law jurisprudence? Or army people have a law separate from the criminal law? No,
But since this is an open fire without any.
doesn't matter. It's a criminal offense after all.
Yes.
It's not a disciplinary action.
Yes. that's-
It's a serious offense.
It is 302 or.
So please come and answer these questions. I mean, don't take it so casually. And maybe we're sorry to say you are taking it quite casually, you and your officer both. Not cooperating with the court procedure in the required manner. You, every day you reiterate one argument that under section 86 it is possible. We have heard that argument a number of days. But the question is little different. Yes, under 86 you can do, but can you also do it in respect of a serious criminal offense? That is the question. Complete answer.
Item 20.
Para 8 of my repetition, I have stated that because they have said that I have unauthorizedly, my lord, kept 30 liters of diesel being the radio line operator. But I have given the, my lord, page 22, my lord, annexure 1, I have given the extracts of leather goods for the relevant date. They said on 24/4/2014.
You are submitting on facts what had happened with you.
Yeah.
We are on. You have challenged a warning letter containing 3 rating entries, saying that a fourth fund will incur discharge.
Third and fourth.
You challenge one charge sheet. Both of them cannot be interfered in this proceeding. One of the last prayer, you also challenge one order dated some 14, where the order itself is not available with us. Other than writing it in the prayer, along with many other prayers,
Yes. In the-
there is nothing before us. So we will give you liberty to challenge that one.
My lord, yes, my lord, I'm.
And if you insist on this one, for inadequacy of material, we dismiss it.
My lord, I'm praying for giving.
No, it's
me-
up to you. If you feel that mentioning one date in the prayer itself is good enough for maintaining a writ petition against that order, we'll dismiss it, saying that inadequate material is available on record to decide that.
Yes, I will be an opportunity to prove myself, my lord, two allegations they.
We
have
cannot
given.
do that. Madam Bora, I think you are understanding very well. You are just showing some perseverance and repeating the same thing again and again. Your entire interest is protected. If you want to challenge that 14 order, liberty is there. But challenge in a proper petition where every particulars will be available. Not just casually writing one date in a prayer in a repetition which is for some other purpose.
In page 36, my lord.
I
they
think
have-
we have given you enough time. You are simply repeating it. And we have also told you a number of times that in the present form, we cannot accept that prayer. Heard MS Boral and counsel for the petitioner, also heard MS RDB and counsel for the CDC for the respondents. The petitioner HAV/ORL Kuldeep Singh has instituted this writ petition with the following prayer. A reading of the prayer A makes it discernible that a writ in the nature of certiorari is sought for, quashing an order dated 3/6/2015 of the Brigadier. What is this? Brigadier CDR, what it is? Of the Brigadier-CDR in the headquarters 26 Sector Assam Rifles, as well as a charge sheet dated 31/1/2015 issued by the Colonel Commandant of 11 Assam Rifles. The order dated 3/6/2015 is extracted as below. A reading of the said order makes it discernible that in fact it is a warning letter, wherein 3 earlier punishments awarded to the petitioner dated 11/11/1995, 13/7/1999, and 1/5/2014 had been referred. And that in respect of the 3 punishments awarded to the petitioner, 3 reading entries had been entered in the dossier of the petitioner. We have been informed by the, whose name do I put? Your name
That's-
or Mr. RKD Chaudhary's? Both of you cannot appear.
That's-
Your name or his name? We informed by MSR Devi, learned CGC, that reading entries are made against each of the punishments that may be meted to a particular member of the Assam Rifles. And the reading itself is not a punishment,
Yes.
but it is a consequential entry pursuant to a punishment being inflicted in a given proceeding. The warning letter of 3/6/2015 further provides that, informs the petitioner that as 3 reading entries had already been entered in his dossier, the 4th reading entry may entail a discharge from service under the rules. It is stated by MSR Devi and Council CGC that in a circumstance where 4 reading entries are made in respect of a particular member of the force, comma, the same by itself entails a discharge from service. As the order dated 3/6/2015 ACLD in district petition is in fact a warning letter informing the petitioner that 3 rating entries had already made in his dossier, and the 4th may entail discharge from service, comma, cannot in any view be said to be in violation of any law, or that it violates any of the legal rights of the petitioner. In fact, the warning letter can be appreciated to the extent that the petitioner had been duly warned and informed about his status in the service. The prayer A also assails a charge sheet dated 13/1/2015 of the Colonel Commandant 11 Assam Rifles. A perusal of the charge sheet, the contents of the charge sheet is extracted as below, page 24. Right? A perusal of the charge sheet makes it discernible that there was an allegation against the petitioner that he was found absent from the place of duty, whereas on the other hand, he was found at Futsero Market on 9/1/2015 at about 17:30 hours. No reasons had been set forth by the petitioner on the unsustainability of the aforesaid charge sheet, other than taking a stand that the charge itself is factually incorrect. If it is the stand of the petitioner that the charge itself is incorrect, the appropriate remedy would be to respond to the charge sheet and establish the fact before the authorities that the charge may be not based on truth. But taking a mere stand in the writ petition that the allegation contained in the charge sheet is false or incorrect. Keep a look, no sentence. Cannot entail the petitioner for an interference with the charge sheet unless some further materials are provided that either the charge sheet is without jurisdiction or it is in aberration of any procedural law. The prayer B of the petitioner seeking for a direction that no disciplinary action be taken against the petitioner pursuant to the letter dated 3/6/2015, it is already noticed that the letter dated 3/6/2015 is not the initiation of any disciplinary action, but it is merely a warning letter informing the petitioner that 3 rating entries had already been entered in his dossier, and that a 4th may entail the consequence of discharge from service. From such point of view, the prayer made for a direction that no disciplinary action be taken also cannot be accepted. Prayer C is for a writ in the nature of prohibition, prohibiting the respondent from mentally torturing the petitioner. Madam Bora, under what circumstance a writ of prohibition lies? And against whom does it lie? Proceed. Prohibited from mentally torturing the petitioner. No materials are available in the petition as to what kind of mental torture has been inflicted on the petitioner, other than the materials indicating that some kind of a disciplinary action is sought to be taken. And further, a writ of prohibition is maintainable only in a circumstance when an inferior court, tribunal, or a quasi-judicial or any authority exercising a quasi-judicial function acts in a manner beyond its jurisdiction. No such material is available to support the prayer number C that the respondents had acted in any manner beyond their jurisdiction. From such point of view, we do not find the maintainability of any writ in the nature of prohibition. The prayer D is for prohibiting the respondents from taking cognizance of the punishment entries awarded to the petitioner on 1/5/2014 and 13/1/2015. By the order of 1/5/2015, the petitioner was imposed the punishment of severe reprimand for having been in unauthorized possession of 30 liters of high-speed diesel. Then the learned counsel for the petitioner, Ms. S. Bora, seeks to substantiate that it is factually incorrect that the petitioner was in unauthorized possession of 30 liters of high-speed diesel, and therefore the order is bad. But it is noticed that by district petition, the petitioner has not assailed the order dated 1/5/2014 or the procedure adopted in arriving at such order. But rather the challenge is, the prayer is to prohibit the respondents from taking cognizance of an order of punishment. If the order of punishment is on record and it is not assailed in any manner in the bringing forth its illegality, no direction can be issued to the respondent authority not to take note of the said order. From such point of further, with respect to prayer D, that the punishment entries awarded to the petitioner on 13/1/2015 be also interfered, comma, it is reiterated, comma, as concluded above, that 13/1/2015 is merely a charge sheet and not an entry of imposing any punishment. For both the reasons, the prayer D is also unacceptable. Full stop. It is stated that in the meantime, the charge sheet dated 13/1/2015 had resulted in an order of punishment. Madam Devi, it has resulted in an order of punishment. The charge sheet
Yes, Lordship.
had resulted in an order of punishment
Lordship, severe reprimand.
of a further severe reprimand, which the authorities are now taking it to be the fourth reading entry and accordingly had discharged the petitioner. In the circumstance although we are unable to accept the writ petition in its present form, but however, it is also recognized that if the charge sheet dated 13/1/2015 had resulted in an order of punishment and correspondingly the fourth reading entry, the petitioner has a legal right to challenge the order of punishment pursuant to the charge sheet dated 13/1/2015, including the procedure that may have been adopted in reaching such order of punishment. Similarly, if the petitioner is aggrieved by the order dated 1/5/2014 imposing the punishment of severe reprimand, again the said order and the procedure adopted thereto would have to be challenged. And a mere prayer not to take note of such orders of punishment cannot be said to be sufficient to take a view that both the orders of punishment and the procedure thereof had also been essayed. In the circumstance, while otherwise dismissing the writ petition in respect of the praise number A, B, C, D, and E, we grant liberty to assail the order dated 1/5/2014 and the procedure adopted thereof, as well as any such order of punishment that may have been made pursuant to the charge sheet dated 13/1/2015, if so advised. Writ petition accordingly closed.
Item 6.
Name is it. The Prism, your lordship, it was appointed as EDA member. Regarding pensionary benefit, my lord. He was, there was advertisement on 2nd of April 1983, my lord. And he appeared in the advertisement. And thereafter, director of rural development has appointed him, my lord, for a post of, and he was posted at DRD. And already, my lord, the project director has come to a finding
Original
that
service book has been placed. Reading of service book is that the
There is
petition
earlier
was
point of
initially
time.
appointed as a Mondal. Temporary basis. Thereafter, he was placed in the scale of so and so. In the process, he was allowed to increment and he was also allowed to cross the efficiency bar. The petitioner also appears to have been granted earned leave from the ISN and then makes an endorsement. The service of providing the petitioner will be facing retrenchment from the.
that is prior to 83. my lord.
And just a minute, and accordingly was released from the office.
That was prior to 83, my lord.
Understand?
Then
Mr. Kumar,
yes, your lordship.
these various orders initially appointed as temporary basis, then settlement officer 1/8/1979, he was released 28/5/1981, deputy commissioner made him join the Mohkuma Porihad. Then 26/5/1982, released from Mohkuma Porihad and made to work as LDA under the NREP. Then thereafter placed at the disposal of the DRDA, where he continued to work. These are individual independent appointments, or these are
Your lordship,
they have to be continuous service.
your lordship,
Only thing, it's a matter like posting. where the man will work. What is according to you?
Lordship, in the service book, they have used.
No, we don't know. We have read the service book.
The trends,
Please answer the question.
yes, sir.
Because in one of the order, there is a reference of retrenchment also.
Yes,
Retrenchment is what? You leave the service.
yes,
The employer-employee relation is severed. After, say, retrenchment and retirement is same thing.
may not be, your Lordship.
No. The employer-employee relation is severed in both.
Yes.
Layoff likely.
Uh-huh.
Yes,
So now after retirement, if a man is re-employed, it is never the continuous service.
yes,
It is like that of a fresh appointment. So after retrenchment, when a man is out of service, then he's again brought back to service. That means it must be a fresh appointment.
yes,
It cannot be the earlier one.
yes,
But here the difficulty we are getting that he will be facing retrenchment, that is in future. If he remains in this post under the settlement officer, there's a likelihood of facing retrenchment. So what you do before he faces retrenchment, bring him to the Mohkuma Parishad.
yes.
So how will you legally interpret it? So whether this man is in service or the man is not in continuous service.
Your Lordship, the,
And mind you, your answer will have a lot of value. And it has to be a specific answer.
yes,
It cannot be that today for convenience, I feel like saying this, let me say this today. Tomorrow argument will go further, I'll say something else, not
yes,
that. So you file an affidavit. We'll take it up on 15th of June. Now, who will file this affidavit?
your Lordship, the, on the earlier date, your Lordship.
No, let the chief
Deputy
secretary,
Commissioner was
let
directed,
the chief secretary to the government of Assam file the affidavit. Because this is multiple departments.
yes, your Lordship.
Multiple departments, deputy commissioner, settlement officer, all various different disjointed authorities are there.
My respectful
So
submissions,
let the chief secretary examine the entire record, file an affidavit whether the subsequent postings are fresh appointments or the subsequent postings are part and parcel of the same service. Only thing, the man is, and mind you, after all, it is one government of Assam. Departments are only for administrative convenience.
yes. Your Lordship, the, I would place.
So you file this affidavit, we'll hear you. Otherwise, it's futile. See, if this is a continuous service, one service, the man is only given different kind of posting. Today in deputy commissioner office, tomorrow as Mondal, thirdly as settlement officer, then Mohkuma Parishad, then DRDA. Then these are postings. If it is postings, this is one service. And his entire service period will be counted to be one service.
I have seen that in the entire period, your Lordship, same service book has been maintained, your Lordship. Same service.
Understand. And on the other hand, if every posting is an independent appointment, say today he's temporarily appointed, work for 2 years. When he goes, again appoint him as something else, work for another 5 years. That is over. Again appoint the same man, there's a very reliable person in the office, give him the third appointment somewhere. If it is disjointed and independent appointments, then it is not one service. Then we'll have to interpret the pension rules and find out what will be the implication thereof. And now the biggest difficulty is you are taking a stand that DRDA is a society. So as a man ultimately retired from DRDA,
Your Lordship,
so the government, he is an employee of the society, no pension.
Your Lordship, yes, in the affidavit, the department has taken this system.
But
Understand?
project director says otherwise, right?
Your Lordship, I have examined the,
So best course.
I have received
No,
a
best
report.
course open is let the chief secretary file. It's a too complicated a factual matter. Because chief secretary is in charge of all the departments. there cannot be any interdepartmental barrier for the chief secretary to take a call. Let him file an affidavit. Then we proceed.
But after appraisal of the records, it is almost established that he was appointed in 1983
Huh.
as UDA by the Director, Panchayat and Rural Development.
1983.
There is annexure, your lordship, fine.
In the repetition, it is annexed, the appointment order, Your Lordship.
The page 23,
Appointed by the
Director of Rural Development.
Rural Development. At present.
the
it-
DRDA.
No. Your Lordship.
That is another department.
Department.
Earlier, the Panchayat and Rural Development was.
No,
Commissioner, Panchayat and Rural
on
Development was.
26/5/1982,
Yeah.
you are placed at the disposal of the project director DRDA.
Yeah, then he applied for, there was an advertisement made. In 2nd of April 83, he applied for that post. And accordingly, his appointment was, that is on page 23, 10 November 83. He was
Page number 23.
23, your lord.
He was appointed by Director,
Rural Development.
Rural Development. Now it is known as Commissioner, Panchayat and Rural Development. Your Lordship.
Here is the problem, Mr. Kotoki. It will go against you. If you consider this to be a fresh appointment, all your past services from 65,
understand.
it will be obliterated. Now you are appointed in the DRDA.
Not DRDA.
DRDA,
No, no, I was actually, I applied for a post of block. my lord.
whatever it is,
You-
look
you-
at
UDA. Yeah, advertisement is for UDA, man.
Mr. Kotoki, read page 23.
Yes, I understand, my lord.
Read the complete sentence. Don't read the half the sentence.
He is working as a LDA in US District Rural Development, hereby appointed
Hereby appointed. Where? As UDA.
UDA,
In
District of Rural Development.
no, in District Rural Development
Development
Agency,
Agency,
that is
Diru.
called DRDA.
But he has taken the earlier service report, my lord. So
Mr.
that is the difficulty, my lord.
That will not help you.
You understand, man?
If this is a fresh advertisement, if it is a fresh appointment pursuant to an advertisement, you are now before the court only as an employee of the DRDA.
No, but the order
Just a
doesn't say, my lord.
No, service matters, you can't do it like that.
I understand.
Just one word borrowed from here that everything will be changed. No, you have to look into a much deeper detail, what actually had happened. So if you construe this to be an appointment by participating in a new recruitment process,
Yes, ma'am.
that means you have abandoned all your earlier services.
Yeah, I understand, ma'am.
And once you are appointed in DRDA, their stand is it is a society no pension. That will be binding on you.
I understand. But the order, your lordship may kindly see, order also doesn't reflect that in pursuant to an advertisement I was appointed. That is a difficulty, my lord.
But you participated.
I understand, but your lordship may kindly see.
Mr. Kotoki, we are not in a criminal jurisprudence.
I understand, my lord.
This is not a criminal case.
I understand.
That the order does not state, that means there is no advertising.
Your lord, because I was, at that time, I was working as a LDA, man.
Whatever it is,
Yes, I.
you have to look into the records. If the record says there is advertisement, you participated,
That-
means you
that was
participated.
advertisement, ma'am.
None mentioning the word advertisement will not make the advertisement disappear.
Because the select list is also not there, my lord.
Not, then your appointment is illegal. You'll be even more bigger trouble.
In the department, Your Lordship, the selection list, they are saying it
Mr.
is missing.
Kotoki, the
Misplaced.
more you are trying to make out your case from page 23,
Yeah, I understand, my lord.
you are
Because-
getting into more deeper and deeper trouble now.
There is no select list also is there, my lord. It's missing, my lord.
Then it is your illegal appointment. You're not entitled to nothing then.
So. And the project director, health manager, I was a government servant, my lord.
Very well.
They have deduct my pension also, my lord.
It doesn't matter. Not pension, that NPS.
And everything has deducted from my salary.
NPS, you'll get back your contribution.
And that
No one can stop you from, that is your money, you'll get it back.
the project health manager is a government employee of Panchayat and Rural Development Department, my lord. That is, and space 31, my lord.
Mr. Kotoki, in other words, this is under the service law jurisprudence. Here, everything goes by the provision of the
Yeah, I
law.
understand, my lord.
More than one word written here, two words not written there.
Because Fact
So
is that-
you make out your case?
that- but it appears that there was a continuous service.
But
Right.
therefore, to help you, we are trying to
Yes,
get an
that will be
affidavit,
better.
and if you are not liking it, we'll hear you from page 23, it doesn't matter.
Because that, it appears there was a continuous service, my lord.
Prima facie, it indicates if we start your career from page 23,
Yeah, understand. my lord.
you will end up in a conclusion that you are an employee of the DRDA by a direct recruitment. So you are governed by the terms of the DRDA. DRDA is a society, there is nothing for you.
Yes, I understand.
Yes, sir.
Mm. But this kind of, it's a very peculiar circumstance.
Yes, sir.
One man, few years here, few years there, few years there, and all are government authorities. Then ultimately nowhere to post him, send him to DRDA. And there you make him work for the next, I don't know how many years.
The government also allowed him to cross the efficiency bar.
Everything is
Everything
there.
is there.
So let
It was
the
it
chief
was one
secretary,
promotion also.
let
Yeah.
the chief secretary take a call then. That's the only way out. By our earlier order, of 14/3/2023, it was noticed as extracted. It was extracted for illegal, entire order too. It is further taken note that by an order dated 10/11/1983 of the Director of Rural Development Assam, the petitioner was appointed on temporary basis as UDA in the District Rural Development Agency, Dibrugarh. It is stated by Mr. K. Kumar, Additional Advocate General, representing the Panchayat and Rural Development Department, that the said appointment was pursuant to an advertisement where the petitioner had participated. If it is so, the order of appointment of 10/11/1983 may have to be construed to be an independent, to be an order of appointment through direct recruitment against a post in the DRDA. Mr. Kumar further submits that DRDA is a society. The legal status of the DRDA is society, and therefore, as it is not a government department, so pension rules are not applicable in favor of the petitioner.
Not a pensionable establishment.
Pension rules are not applicable. But when you take note of the service history of the petitioner recorded in the aforementioned order dated 14/3/2023, it may be noticed that the petitioner was initially appointed as a Mandal on temporary basis on 9/10/1965. Thereafter, and were also allowed to cross efficiency bar, etc. Then, when the office of the Assistant Settlement Officer, then when there is a likelihood of the office of the Assistant Settlement Officer coming to an end, the petitioner, by an order of the Deputy Commissioner dated 28/5/1981, was given a place of posting in the office of the Mohkuba Porihar, Tinsukia. Thereafter, by another order of the Deputy Commissioner of 26/5/1982, he was given a posting in the governing body, was given a posting as an LDA on a temporary basis under the NREP work, and later on, he was also appointed in the office of the Project Director, DRDA, Dibrugarh. The Chief Secretary to the Government of Assam to file an affidavit taking note of the entire service history of the petitioner, by taking a specific stand with reasons as to whether the petitioner is an employee of the Government of Assam, although it may be that he was posted in under different departments of different departments from time to time, or the records justify that he is not an employee of the government of Assam. The said question assumes importance as it is the stand of the PNRD that the DRDA is a society and not a government department, and therefore the pension rules will provisions will not be applicable. List on 15/6/2023, and it is expected that the affidavit of the chief secretary would be on record before the next returnable date. A copy of the order be given to Mr. K. Kumar.
Can be made party here.
Sorry,
Chief Secretary is not included here.
not required party. We only want his help. We don't want to pass any order against him.
Yes.
Who is a necessary party?
State of Assam
He is not a necessary party.
This
Only thing
copy-
because we require the affidavit of the chief secretary because of the peculiar complicated facts of this case. And therefore, the chief secretary being in charge, being in overall charge of all the departments of the government of Assam would be in a more appropriate situation to take a stand and file the affidavit.
A copy of this order may
A
kindly
copy
be.
of the order. Response.
Oblige.
Seven and eight.
4782 for regulation. Other than 86, what is your submission? Other than your submission that under 86 we can do everything, what is your submission?
Limitation is also there, Lordship.
Sorry,
Certain limitation is also there regarding the summary court proceeding. It is not that absolute power is given to the commander. There is a very under.
so therefore, although the man may be a constable or below, should he be tried by a summary court? Why don't you send him to the regular force court or whatever terms he is used? Give him the satisfaction, give him all the opportunity.
General force code, there is an elaborate procedure.
Sorry,
There is an elaborate procedure in general. force
that's why we want an elaborate procedure. See, certain offenses are also tried in a summary manner. You have seen the magistrate trying some summary offenses. Certain offenses are tried by the magistrate court. Certain offenses only by the CJM court. Certain only by the district, by the session judge. Why? Why 302 is not placed before the magistrate to be tried as a summary trial? Answer is the intricacies and complications of the law and implication thereof is much higher. So CRPC has in place a session judge to try those kind of offenses. There are other petty offenses which can be tried by a summary court. The magistrate can do it. There again, the same procedure. Yes, whether you have done it or not. Say a traffic violation, that is also an offense. It's a penal offense. Yes, we have done it. Please excuse me this time. Okay, pay a fine of about 200 rupees, end of the matter. Gone. There also you follow the same procedure. Call the man, make him appear before the magistrate. Only one question.
procedure is followed.
You are good in argument, but without any basis. That's a difficulty. You just like to say something in between. That's all.
Even the Lordship.
We are trying to very seriously analyze this, but you are just making a mockery of it. Just saying this, and all.
135.
Sorry.
Rule 135. There is
Huh.
a procedure.
Definitely.
Followed in the summary.
So when the charge is a serious charge, why don't you subject him to the more elaborate procedure? Let him have all the opportunity to defend himself, which is not available in a summary proceeding. Sorry.
It is available. It's available as per the law. Because.
And mind you, 86 enables you to try the this constables and below. But
Under.
force court also is not excluded or prohibited. Otherwise, the provision would have been that if it is any offense relating to a constable, force court will not have jurisdiction. It will be only the summary court. Why that provision is not there?
No, sir, for general force court can try any.
Anyone, that's why you are asking. If your argument is to be accepted, that because of 86, as he is a constable, we'll try him only in a summary court. This is your argument for the last several days, madam. Don't change your stand. Please don't change your stand. We don't appreciate that. Please never, don't do it. Don't be don't make opportunistic arguments for nothing. For several days, you are arguing on one point that under 86, there is an empowerment of the summary court to try a man constable and below. This man is a constable and below. Therefore, we tried him under force court. We are responding to that by putting a question, what about when it is a serious offense? Now, if the force court is also empowered to try constables, summary court is also empowered to try constables, which matter will be sent to the force court, which matter will be sent to the summary court? Somebody has to apply the mind. How will you apply the mind? One of the reasonable basis will be on the seriousness of the charge. So what we are doing is, instead of giving him a truncated opportunity of a summary court, place him before the force court. You bring all your material, let him defend howsoever he wants to defend.
Lordship, in the battalion, commandant is the authority to try.
Madam,
Yes,
we have already indicated, these opportunistic arguments are not leading you anywhere. It's not helping you in any manner.
There is also, Lordship, there is limitation regarding summary court, power of the commandant regarding summary court.
So this is what the petitioner is asking for. Give me a more elaborate opportunity to defend myself. Let me be placed in a force court. This is all he's asking. He's never saying that don't punish me. He's never saying that don't try me.
Lordship, actually, he has not challenged the force court, summary court, but he has challenged it. I have not pleaded guilty. He was.
Doesn't matter. Forget about these technicalities. But this argument he is raising. No, his argument he is raising that I never got a good opportunity. All that I got is I was called by the commandant, made him to sit in front of him, yes or no, proceedings over. This is his allegation before the court. Or maybe a little bit, maybe a little bit more than that. But it is not an elaborate procedure giving all the opportunities that an accused is entitled to.
There was also eyewitness statement also.
You are arguing on facts. We are not on facts. We are on the procedure. We are just on the procedure.
Appeal also is.
Suppose today the High Court also starts taking the stand. How do you like? That everything comes, we will do it in a summary manner. We'll try to distinguish between constables and above. If anybody constable and below, we'll do it in a summary manner. Why? He is a constable. Doesn't have much value to the society. If he's an officer, oh, he's an officer. We'll do it in a more complete manner. Will you be happy? No. Same is with your authority. He is not happy. and he's before the court just making one prayer. Give me a good opportunity to defend myself. That's all. Maybe ultimately the order and punishment will be same. We are not on that. We are on his satisfaction of having complete opportunity to defend himself. Pass the order today, or where is the officer gone today? Chakraborty. He's here. He doesn't like to come inside. Follow? And you also do one thing. You'll have to go and surrender yourself before the authorities immediately. They can keep you in detainment. They can keep you in custody. They can do only thing. Yes, Mr. Chakraborty, please come forward.
Already dismissed.
Therefore, he'll be in. Now we are interfering with the dismissal. Please come decide. Ultimately, we have not got the answer. Why? Merely because of Section 86, which enables the commandant to choose between summary court and full court, force court, in respect of persons, constable and below. You have that power. No difficulty with that. But when the allegation is of a serious offense, and mind you, had the statute been such that if it is constable and below, it is summary court. If it is constable and above, it is force court. Then the matter would have been different. Force court also has jurisdiction to try constable and below. So now, which of the cases of the constable you will send to the force court? Which of the cases you will send to the summary court? That will require a decision. How will you decide? One of the basis is the seriousness of the offense. Definitely. And the man charged with a serious offense where the consequences may be much more severe is always entitled to the complete opportunity to defend himself, which is available in a force court and not available in a summary court. So we interfere with the summary court order, ask him to immediately surrender to your custody. You keep him in detainment, you keep him, it is up to you what kind of decision you take, where he will remain. Constitute a force court, give him all the opportunity and pass whatever order you have to pass. Ultimately, the order may be same also, we don't know. But that will take care of his grievance that he did not get the complete opportunity to defend himself. Why don't you do it? Instead of taking all these technical objections here and there, why don't you do it? The morale of your forces will also be high. That, yes, the system will protect us. If the morale of the constable is such that we, because they are a constable, will be subjected to all summary proceeding, whatever we do or we do not do, and simply summarily discharge from the force, will you think their morale will be very high? Tomorrow they may start deserting you. At the vital moment, if they know, suppose you are going on some proper operations, if the requirement of the situation is acting little this way or little that way, they won't, they'll forego their bravery, go for the safer option. Why, if for some reason, if this bravery is interpreted to be kind of an offense, I'll be subjected to a summary inquiry and the very next day I'll be out. Say, sir, why should I take all those risks? Let me also play safe. Will your efficiency and morale of your force not come down? But if you give them a more detailed opportunity to defend anything, we are not saying he had not done anything. He may have done, may not have done, may have done the most serious offense also. If you give him the detail, those members, existing members of your force will feel confident to be with you. Yes, the law is also there for us. How do you lose? Or how you will be prejudiced? Other than the personal ego of the person who had passed that order, minus that, will the forces be prejudiced in any manner?
My lord, there is a provision of second trial in the act. So if honorable.
If you want to invoke, file an affidavit that we are going for second trial, we will accept it. File an affidavit that there is provision under the law for second trial and we are subjecting this person to second trial. File an affidavit.
There is provision.
There is,
No provision for second trial.
but you said,
No, my lord,
Mr. Counsel, Mr. Officer, we are going to set aside your order. Then we won't even give you liberty to do that. We'll say the procedural liberation, the natural justice was violated. We'll set aside, take him back. Then no second trial also, no false court also. Very well. If that is your stand, adamant stand, then we just pass our order. We'll set aside. Then he'll be back into his force. And you mind you, then you cannot hold a second trial. Want to reach that situation?
Lord, take instruction from the.
Get it. Get your instruction. And mind you, we follow law, we don't follow instructions. Instructions is for you, not for the court. For the court, how we look at the law, how we interpret the law. And the basic structure of the Indian Constitution is fairness. Article 14 is one of the basic structure. Is it not a discrimination? By clinging onto a section 86 that this man is a constable, so we'll not even give him the proper opportunity to defend. That's a discrimination of the worst kind. The forces will crumble one day if you maintain this kind of a mental attitude. Security of the nation will suffer for a few officers here and there who are unable to reconcile with themselves. There are many factors we have noticed in this case. And response is, other than adamancy, we are not getting anything from your side. Adamancy and just manipulate and repeat the same thing again and again. That's all. And this is neither responding to a court, nor it's a good lawyering, nothing. And the situation you are heading towards is to interference of this order. Then very well. Second trial is not maintainable. Don't hold it. Take him back in service. Who will suffer? He will suffer. And this hearing has to come to an end. It's going on and on for nothing. Directionless simply. Just because every day you do the same thing. At the end of the proceeding, you come and appear and say something and go back, that I'll look into it. And never to come back to say what you had done after looking into it. Next day again, you start fresh. Section 86, section this, that. And we may make some observations against you also. The officer was most uncooperative. If you feel that the judgment of the court will go against you, my career will be affected. So let me desperately go on repeating the same thing. The observations may be also against you then. It will be even more damaging. Be fair to the people. Be fair to your members of your forces. They are human beings, mind you. Give them the basic human treatment. He may have done a very bad thing or may not have done, we don't know, or under what circumstances he has done also, we don't know. What he's asking, give me a fair opportunity presenting my case, that's all. And you are refusing that. Yes? What do you say? No, just think in a more broader terms rather than the narrower terms which you are already prepared in your mind. They're your superiors. Your superiors are also guardians of the entire force, are they not? And how a guardian is to behave. Take proper care of every member of the force. Are you taking care of your member of the force in this manner? The higher you are, more responsible you should be. Suppose he had not done, then. You have said 3 shots were fired. Suppose he had not done. It was done by somebody else. And you don't give him an opportunity to present his case. There will be committing 2 wrongs. One, you are not giving opportunity to one person. Secondly, you'll be giving opportunity to another who had done it to escape unscathed. Why? Section 86. Section 86 gives me the power, I'll do it, whatever I feel like. Come back and tell us. In spite of repeated hearing on the issue, no appropriate answer is forthcoming from the respondents as to why an allegation of a serious offense should mandatorily be tried by the what court? The summary court process under section 86 of the Act and not by a full force court.
General force.
Sorry?
General force code.
General force court. Section 86 no doubt provides that personnel of constable and below can be tried in a summary court. But again, section 135, full force court, general force court, 135.
Power section 84, my lord.
No, 86 is summary court.
And general force code 84, my lord.
84, কি করলো? Third, কি করলো? Right. But at the same time, section 84 does not anywhere provide that general force court is applicable only to such such members of the force who are above constable. And they have no jurisdiction to try any member who is constable or below. In other words, it has to be understood that for personnel of constable and below, both the summary force code under section 86 and the general force code under section 84 may have a jurisdiction. If 2 authorities have a jurisdiction, the respondents to inform the court as to in what manner the discretion had been exercised, that in the instant case, it would only be the summary force court and not the general force court. The records of the containing the materials under which the discretion, if exercised, be also produced before the court on the next returnable date. Produce it. Otherwise, it's an arbitrary decision. We'll violate Article 14. We'll hear the theory of discretion, doctrine of discretion, what it is. List on 15, maybe 15.6. That day will complete the matter.
All right.
Because there is a difference between a discretion and a whim. If the law would have given you the whim, that as per your whim, you can do either of the two, then you can say, my whim is I do this or I done it. But the law says discretion. Discretion is always reason-based. That these are the circumstances, this is a thing, we feel it will be adequate for a summary court, so we try by summary court. You have to produce that records now. Otherwise, your discretion, exercise of discretion is bad in law. But that's a good reason to interfere. Right. And second trial, not maintainable. Sometime back you submitted that yes, once that happened, that's a finality. No second trial. Are you insisting on that argument? And you produced the entire records. You have the records with you. What is here? Where did you exercise the discretion? Let us see. Point out. Why the authority took the decision that this will be by summary court and not force court? Find out. No such note, we are aware of it. That's why you are putting this question. That means the entire exercise of power is arbitrary. It violated Article 14. And be fair. Your name? Padmanabha, Mr. Padmanabha, be fair. Be fair to your forces, to your members. You'll get them better service from them.